Welcome to the Corruption Files Update. This is your quick hit on the latest filings, breaking news, or bombshell developments in the cases that we follow. No fluff, just the facts that you need right now. Let's dive in. Hello, everyone. Welcome back to Crime in Court with Heather. This is a Corruption Files update. We're going to be talking specifically about Aidan Kearney or Dr. Turtleboy or whatever you want to call him. He goes by many names. So, before we get started, I do want to do a quick thank you to founding members, Toyota Girl 67. These are founding Justice Insiders, I should say. Sorry, not members. Well, they're members of the channel. So Toyota Girl 67, SLB 29488. May the force be with you 4313. Jessica Wienand 6079. Mrs. Apples 2007. Butler 89833. Thank you. Brooke JF. Jen P 773. Boom Chicka Wow Wow 1. And Kendall B 5757. Thank you so much for being founding members of the channel. If you would like to become a founding Justice Insider, you can do that as well by becoming a Justice Insider. That is the highest tier, that is the $2.99 tier of membership, and you will forever be immortalized in videos and on the member wall of fame with your name read off. Or if it gets to be way too much later on, we'll do like a rolling credit or something. But your name will definitely get on screen for being a founding member or founding Justice Insider. So thank you guys. And yeah, there's more information. I recently updated all of the perks. So everything is really interactive or in a way, some way to connect you with the channel. Some of it's recognition. So I really wanted to do it with you guys in mind so that you get recognized and are able to engage more in the channel. All right. So with that being said, let us move on to our main topic. So we're going to be reading through the motion to dismiss, Aidan Kearney's motion to dismiss. I can't remember when it came out, but I believe I was kind of on hiatus at that time and rebranding and whatnot, so I didn't read through it when it came out. So we're going to read through it today. Aidan actually, him and his defense team had a hearing scheduled May 14th to argue this in front of the judge, and unfortunately, there was a loss. I believe Mark Bederow lost one of his dogs, which I can't even if I start talking about it, I'm going to go insane. I lost both of my German Shepherds within 34 days apart. I had them for 12, 13 years. So it's been really rough on me. I'm still really grieving them. Hence why we had room in the house now for a puppy. I love him. I love him dearly, but it's not the same as having my shepherds who were with me through everything. So if anybody else out there is grieving a pet, my condolences to you. It sucks. It sucks so bad. It's hard. I don't have kids. They were my kids. So it's hard. Anyways, we're going to move on to the reading. So they were supposed to have May 14th, they were supposed to have a hearing. It got canceled or rescheduled, although there isn't a new date yet on the docket for this argument, for them to argue this in front of the judge. But it should be, hopefully they schedule it soon. So this particular document is an 88-page filing from Mr. Bederow. As you can see, Mark A. Bederow, admitted for Commonwealth, affirms under penalty and perjury the following. So we're going to read through the following. He has excellent filings. He also gives a ton of links. We're going to click on some of the links just to see what they are. We're not going to go through and read everything in depth, but we'll go through some of the links. I don't want to be here forever reading it because it is a long document, but I think it's important to kind of give some context to what they're talking about. So throughout, we may switch back and forth to some of these hyperlinks in here. So Mark Bederow affirms the following. 1. I am an attorney of record for the defendant, Aidan Kearney. I am familiar with the facts and circumstances herein and make this affidavit in support of Mr. Kearney's motions for dismissal of the indictments pursuant to the Commonwealth versus Odell and its progeny due to the prosecution's impairment of the integrity of the grand jury proceeding, or in the alternative for the granting of an evidentiary hearing connection with the motion. So, because of the way in which the grand jury proceedings were handled in order to get the indictment for Kearney, they think that it was lacking integrity. So they want to either have the case dismissed entirely, or they want a hearing in order to put evidence forth on the record for the judge to evaluate. And that would be interesting if we get an evidentiary hearing. That would be, I think, that would be some good television to watch if they start, bringing Kate Peter on the stand and things like that. Maybe even Tully. All right, so the dismissal of the indictments pursuant to Bridgman versus District Attorney for Suffolk County and its progeny due to the Commonwealth's pervasive failure to disclose specifically requested Brady and Giglio material and automatic discovery under Rule 14 of the Massachusetts Criminal Procedure or an evidentiary hearing. So, because they failed to turn over the discovery that they should have turned over, that's another reason why they want it dismissed. And then also, they are asking for the disqualification of Special Prosecutor Kenneth Mello pursuant to Rule 3.7 of the Massachusetts Rules of Professional Conduct due to Mr. Mello being an essential defense witness at trial or in the alternative, an evidentiary hearing in connection with the motion. So the third reason they want it dismissed is because Ken Mello is a witness in the case. So he can't, I'm sure if we click on Rule 3.7, it's going to say that they can't, an attorney cannot be both a witness and a whatchamacallit, a presiding attorney on the case. All right. So background. Mr. Kearney, known as the moniker Turtleboy, is a credentialed independent journalist with large platforms on social media and YouTube. He writes articles and regularly hosts live YouTube shows, which generally are 2 to 3 hours in length and address numerous topics of public concern. Mr. Kearney's YouTube videos are categorized sequentially as numerical episodes, each of which contains a unique title summarizing the contents of his episodes. I don't know who does his titles and thumbnails. I think it's the chick Laura or Lauren that's like in the UK for him that does all of that stuff, but she's really good at like episode titles and thumbnails and stuff. Each episode and titles of Mr. Kearney's shows are displayed prominently on his YouTube page and may be viewed by anyone, irrespective of whether they subscribe to his channel. Mr. Kearney's investigative reporting has exposed numerous examples of fraud, corruption, and wrongdoing. He often intersperses his journalism with elements of comedy, satire, and activism. He's not just a one-trick pony. He's all these things. He's a reporter, he's a comedian, he's a satirist, and an activist. Not surprisingly, many people who become the subject of his reporting and content don't like him. He's controversial in the way that he exposes people. When you expose someone for doing something wrong, sometimes those people who may or may not already be criminals might take that the wrong way and go after you to attack you, the person who exposed them, not the people that are responsible, which would be you, the person doing the illegal things or whatever. But that's how Turtleboy gets his enemies. Usually he exposes someone and then they get mad. They were a fan and then all of a sudden, nope, I don't like them anymore. And they try to attack him. It's crazy the amount of people that try to take Turtleboy down and he just keeps rising up. In April 2023, Mr. Kearney began researching the Karen Reed case, which at the time appeared to be a straightforward, open and shut vehicular homicide case. After he reviewed publicly filed documents and acquired information from sources he generated, Mr. Kearney quickly realized that the case against Ms. Reed was far more nuanced than he had publicly reported up to that point. Since he first delved into the circumstances surrounding how John O'Keefe and Boston police officer ended up dead on the front lawn of fellow Boston police officer Brian Albert. Sorry, my Norton was going to run a scan right now. I had to stop it. Since he first delved into the reporting, shortly after Ms. Reed dropped him off at Mr. Albert's Canton home in her Lexus, Mr. Kearney's reporting and content creation has centered on his unabashed belief that the Norfolk County DA's office and the Massachusetts State Police framed Ms. Reed with assistance from Jennifer McCabe and members of the Albert family and others who participated in Mr. O'Keefe's death and or helped cover it up. We have our first footnote here. Ms. McCabe's sister, Nicole, is married to Brian Albert. So I'm just pointing out the relationship there. On April 18th, 2023, Mr. Kearney published his first article about the Reed case, Canton Cover-Up 1, Corrupt State Trooper Helps Boston Cop Cover Up Murder of Fellow Officer Frame Innocent Girl. So this is his first publication. And where did I have it here? So this is his very first Canton cover-up. He, gives the background of the story. I'm not going to read through all of it, but he originally believes that she was framed. Using all the pictures, he's got documentation. He's got pictures of Michael Proctor here. So that was his first. Ooh, there's Jen McCabe, Brian Albert. So he goes into in depth talking about all of it and explaining Trooper Proctor was friends with the McCabe family, and when Colin was in Proctor's sister's wedding and they're like family. Those kinds of things are what he started reporting on way early in the beginning. So that was his first article, already talking about that stuff. Mr. Kearney's initial Canton cover-up report was primarily sourced by the April 12, 2023 90-plus page court filing from Ms. Reed's defense, which consisted of an affidavit from her attorneys supported by numerous exhibits, including police reports and data from an extraction report of Ms. McCabe's cell phone. So it was a very lengthy affidavit, but it is an affidavit of Alan Jackson that you can see. Let me zoom this in here. Affidavit of Alan Jackson in support of the motion to get Brian Albert's Verizon and AT&T. And I think Jen McCabe was on here too, that they wanted Jen McCabe, or maybe this is just Brian's. But yeah, so that's what he put forth, and it's 92 pages long, so we're not going to go through that. But that was where Aidan got most of his reporting from, right? So they're proving that that was all in there. Mr. Kearney reported that Brian Albert, Ms. McCabe, Matthew McCabe, Chris Albert, Colin Albert, and Julie Nagel were definitely in the house at the time Mr. O'Keefe was killed, and that all of them witnessed the murder or are aware of it and have said nothing. Most of them were not questioned by now terminated and disgraced Trooper Michael Proctor. Mr. Kearney's article highlighted the Reed's defense claim that Ms. McCabe Googled "House Long to Die in Cold" at 2:27 a.m. on January 29, 2022, which, if true, was damning evidence of her complicity in and or knowledge of the circumstances surrounding Mr. O'Keefe's death. Most of the individualized most of the sorry, my tongue is not doing what I'm trying to tell it to do. Most of the individuals criticized in Mr. Kearney's April 18th, 2023 article for their alleged involvement in Mr. O'Keefe's death or its cover up later became the allegedly intimidated witnesses in the indictments against Mr. Kearney. Indictments related to Mr. Kearney's purported intimidation of Mr. Proctor and Sergeant Urey were later dismissed by a court. I don't know if I have that one open. Hold on. Here is Judge Doolin's ruling from May 19th, 2025. It's a lengthy ruling, which goes over all the reasons why he's dismissing the charges for Urey and Proctor, but then the other ones are denied. Everything else was denied. He still has, I believe it's 12 indictments that are left. 10 of them come from it's 10 indictments. 10 of them come from the 2023 indictment, that the original indictment, and then there were some other things that were dismissed as to the Lindsay Gattani abuse allegations that was dropped, and what else was, I can't remember now. Something else was dropped, but and he still has that witness intimidation window thing that came up, so those are newer charges. They're trying to charge him on witness intimidation for talking to a camera at for in Chris Albert's pizza shop window. That's what that one's about. All right, so I will have you know what? I can download these and put them in a folder. So anyone who is an insider, either a core or a Justice Insider, you can get access to all of these files. I'll have a file just for Turtleboy's motion to dismiss that has most of these links and things attached. All right, so that was the motion to dismiss, or earlier there was a previous motion to dismiss, and that's when Urey's and Proctor's, because they're law enforcement, they shouldn't be intimidated. That's when those charges were dismissed. Mr. Kearney's well-sourced, dogged reporting and outspoken support of Ms. Reed's innocence lit the spark that quickly ignited the Free Karen Reed movement, a phenomenon which galvanized worldwide support for Ms. Reed and relentless, blistering criticism of the DA, MSP, and the civilians whom Mr. Kearney and many others believe concealed the truth about Mr. O'Keefe's death. Mr. Kearney's coverage of the Reed case, which to date includes 528 Canton cover-up articles and hundreds of video episodes, virtually overnight transformed a mundane Massachusetts criminal case into perhaps the most high-profile and scandalous murder prosecution in the United States in decades. That's a Fox News article. We don't need to look at that. Mr. Kearney's frequent reporting on the Reed case has played a substantial role in the public's loss of confidence in the integrity and competence of Norfolk County law enforcement, an ongoing scandal that continues to plague the DA and MSP in the aftermath of Ms. Reed's acquittal. We have another footnote here that says Mr. Kearney's exposure of the DA's and MSP's misconduct into the Reed case has complicated the murder cases against Brian Walsh and Miles King. It has led to significant criticism of the DA's investigation into the death of Sandra Birchmore, which it classified as a tragic self-unaliving, but which many believe was a whitewash. In 2024, the U.S. Attorney's Office thoroughly rejected the DA's findings and indicted former police officer Matthew Farwell for Ms. Birchmore's murder. But for Mr. Kearney's reporting, disgraced former Trooper Proctor would still be investigating serious cases for the MSP. If Turtleboy hadn't been doing this reporting, Michael Proctor would still be a detective for the MSP doing whatever it is he does or did framing innocent women and looking for nudes. That's what he will forever be famous for. Other members of the MSP, including Detective Lieutenant Tully, Brian Tully, and who was the lead investigator against Mr. Kearney and Sergeant Buchanan, wouldn't have been publicly disciplined for their misconduct, and the Norfolk County's State Police Detective Unit wouldn't have been dismantled due to their misconduct in the case. And that is an NBC Boston article that links to. So basically, crediting Aidan for reporting on this and shining a light on the corruption, which then led to all of the people, almost all of the investigators, having some kind of disciplinary action or something happen to them. Except Fanning. Nothing's happened to Fanning yet, so I'm waiting for that. He did investigate, he did the forensic data for Karen Reed and also the Sandra Birchmore case, where he missed 37,000 text messages between Sandra Birchmore and Matthew Farwell. 37, not 3,700, 37,000. Missed them all. Although Mr. Kearney's reporting on the Reed case raised disturbing questions about the possibility of systemic corruption in Norfolk County and gained him tens of thousands of supporters, the public officials and private citizens he has accused of wrongdoing and the microscopic segment of the population who remained convinced of Ms. Reed's guilt, despite her acquittal, despise him for his coverage and opinions. Since Mr. Kearney exposed the scandal surrounding the Reed case on April 18, 2023, the DA, MSP, Ms. McCabe, and the Alberts have repeatedly used the criminal justice system as the instrument to silence Turtleboy and end the persistent criticism his reporting has caused and still causes them today. So, perfectly summarized statement of what is happening. Michael Morrissey, Brian Tully, and others within the state police, McCabe, and the Alberts have repeatedly weaponized the criminal justice system against him solely to shut him up. They don't like what he's saying. Summary of the motions. The primary evidence used to secure Mr. Kearney's indictments were shortened, edited, and renamed segments from his hours-long YouTube episodes, which had the effect of skewing the true context of Mr. Kearney's episodes. For months prior to the grand jury proceeding, DL Tully and Mr. Mello were familiar with Mr. Kearney's actual episodes, including their true names, length, and context. So they're claiming, the defense is claiming, that the Commonwealth, including Tully and Mello, all knew the true names of his videos, what they were really called or titled, which comes into play later, how long they were, and what the context was of each of the videos. But they twisted a lot of it and made up some shit. So during the 2 months prior to the grand jury proceeding, DL Tully and Mr. Mello welcomed unvetted evidence and guidance from Katherine Peter, a private citizen who they knew harbored an unhealthy obsession and hatred for Mr. Kearney. Ms. Peters' dreadful credibility included indictments in 2020 and 2023 where she falsified and forged evidence to harm Mr. Kearney, the latter of which included her audacious defamation and exploitation of Colin Albert and Chris Albert to further her insatiable urge to embarrass Mr. Kearney. So, Kate Peter, let's break this down one by one. In the past, in 2020, she forged court documents. Where are we at? Oh, I forgot to show you some of those other links were to the trial board findings of different officers like Proctor, Tully, Yuri. Those will all be in that folder on the Justice Insiders or the Insiders folder. Um, it's just an article about them all being rehomed, the officers being rehomed. So Kate Peter, this is the article that Turtleboy wrote about Kate Peter drafted a fraudulent federal complaint against me for copyright in order to get a YouTube video removed, but used an already existent document. So she took a document that already existed, a filing that somebody already filed. She took it, reworded it. She edited out all the text and put like her own words in there to make it fit. But she left the docket number because she's not that smart. So they found her, or they were able to discover that this was not a real case. But she used it in order to strike Turtle Boy's videos to get a copyright strike on his channel. And she used falsified documentation. That's what that article is about. And then the other portion of that sentence or paragraph is the defamation and exploitation of Colin Albert and Chris Albert. So this is, I don't know who this is to. Mia Rose writes, who's she writing to? I have no idea. Well, let's read it because I don't even know what this is. So it says, "Hi, I've been really scared to talk to anyone about this, and I know I'm not the only one, but I see that you are keeping people anonymous, and I think it's important people know. The problem that Colin Albert had with John O'Keefe was that Colin Albert sells pills and weed, and John knew about it because he lived across the street from one of Colin's friends who runs with Colin. Colin's dad knows, and sometimes the drugs go through the pizza shop, from what I've heard. The whole Albert family makes money from it, and I don't know if his Uncle Brian knows or not, but I think he probably does, and that explains what they are really covering up. I have screenshots of Colin selling drugs and stuff because sadly I have bought from him before, but I don't really want anyone to know that or know I said anything. Colin talked a lot about getting of John because Colin thought John had him under surveillance, but I don't know if he really did. He was also a huge part of bullying this girl, Erin Beatty, pretty bad. Shows what kind of person he really is. I think what happened is he followed through with what he was saying about John. And this is a communication exchange apparently. Do you need any pure? Got the or got the proper power chong bit of flake if you need. Banging bit of stuff in. Can do deals too. About all night from 8. Same banging bit of pure and skunk. Sour diesel plus pure will be about within the hour. These must be names of drugs. And then it's the person. Oh, that was to Aidan Kearney. That was Kate Peter wrote that under a Mia Rose name, but she sent that to Aidan Kearney. And then he says, "Hi Mia, you are safe here. I never reveal the names of sources. I'm interested in seeing the screenshots of Colin selling drugs if you'd feel safe sharing them. Did Colin ever say anything about John in writing? And what exactly did they do to Erin Beatty and why?" So that was Aidan's follow-up. But now you know that was all Kate Peter who wrote that, trying to stir up some gossip that wasn't true to see if Aidan would report on it. That was pretty much her whole goal in doing that. Ms. Peter provided DL Tully and Mr. Mello with video and audio evidence, including edits from Mr. Kearney's lengthy episodes, which she believed evinced Mr. Kearney's intent to intimidate witnesses. As detailed in the accompanying affidavit of Courtney Healy, according to DL Tully, Ms. Peter directed him to specific timestamps of Mr. Kearney's episodes, which he located and edited, rather than review the linked files provided to him by Ms. Peter. DL Tully apparently renamed the edits he made from Mr. Kearney's episodes such that they didn't accurately reflect the names created by Mr. Kearney. So, K. Peter sends episode links with timestamps saying, here's where he's saying whatever, blah, blah, blah. Go there. And Tully gets them and he renames them to something else that doesn't reflect what's actually in the video. And he saved them in folders that he created, which included at least one he named intent. So he, in his evidence that they displayed on the screen to the jury, he had a file explorer folder that said intent. It was named intent, and under there was the links to all of Aidan's the clips of the videos that they were using in the grand jury, which were renamed by Brian Tully. So the grand jury is seeing evidence titled intent and then gonna get you, or your head should be on a swivel, or whatever it is, like whatever, they titled it. So that's what the grand jury is seeing, and they don't know that that's not what Aidan titled it. The edited and renamed files and the intent folders DL Tully created were the exact files that became the exhibits that Mr. Mello introduced and DL Tully described before the grand jury. Mr. Mello's direction of the grand jury proceeding made a mockery of Mr. Kearney's right to due process, the cumulative impact of which impaired the integrity of the grand jury proceeding and prejudiced Mr. Kearney. Mr. Mello littered the grand jury proceeding with his improper comments, his unsworn opinions of the evidence, and Mr. Kearney's intent, and by twice eliciting D.L. Tully's opinion that Mr. Kearney intended to intimidate the witnesses. How does Tully know the intention in Kearney's heart? How does he know that? And for Mello to be making improper comments, unsworn opinions about the evidence, and talking about Kearney's intent is also very improper and could be a problem for the Commonwealth. Mr. Mello provided the grand jury with improper legal instructions and failed to give appropriate limiting instructions. He improperly alerted the grand jury about the possible sentences associated with the crimes for which he sought indictments. You're not supposed to do that. They're not supposed to think about punishment at all when they decide. Well, I guess for this it would be, is it probable cause? I don't remember what the threshold is. Is it probable cause that they use for the grand juries? I think. I can't remember. So possible sentences associated with the crimes for which he sought indictments. They're not supposed to mention that, and even a charge for which he did not seek an indictment. So he talked about evidence for a charge that I think it was wiretapping of Steve Scanlon, and he never even thought the charge for that. So, but he put that in front of the grand jury. So that's more prejudicial than anything. Mr. Mello dedicated the first day of the grand jury proceeding to dirtying up Mr. Kearney through his introduction of irrelevant and prejudicial evidence related to an uncharged allegation of Mr. Kearney's wiretapping Stephen Scanlon, a topic entirely unrelated to the witness intimidation allegations before the grand jury. So that was not even before the grand jury, yet he brought it up. And Steve Scanlon, in case you forgot, is the man. This interview is out now. You can listen to it on the internet. So Steve Scanlon is the one who called David Yannetti and gave him the tip that Karen didn't do this, but some people in the house may have, and you might want to look into Colin too. So that's where that came from, is Steve Scanlon. Mr. Mello and DL Tully misled the grand jury by limiting evidence of Mr. Kearney's intent to DL Tully's edits of his episodes, which left the grand jury with inaccurate and far more incriminating information about the names, length, and context of Mr. Kearney's episodes, rather than affording the grand jury access to his authentic episodes, which would have provided it with the accurate and favorable context of Kearney's statements. So the titles were more accurately and appropriately named. At least 28 times during the course of the grand jury proceedings, Mr. Mello elicited from D.L. Tully materially false and misleading testimony. False and misleading testimony in front of the grand jury about Kearney's YouTube episodes, which gave the grand jury the false impression that he created the episodes to document his alleged intimidation of witnesses. Despite numerous defense demands for specific evidence from September 24 to August 25th, the DA has failed to disclose exculpatory or discoverable evidence, or, at a minimum, explained what efforts, if any, it made to locate the requested evidence. So we're still looking for evidence, Judge, and the state's not turning anything over. The defense made a prior defense motion to dismiss the indictments without access to important undisclosed information or evidence that was in the Commonwealth's possession, custody, and control prior to the filing of the motion. So this is going to be, I'm sure, the motion. So that does go to this, which is Aidan Kearney's first motion to dismiss, which was where it was granted that Proctor and Buchanan's witness intimidation charges be dropped. So that's his first motion to dismiss, which I believe we did read on my channel. So communications between Ms. Peter, Mr. Mello, and DL Tully, which are relevant to the instant motion to dismiss the indictment, have been in the Commonwealth's possession, custody, and control since 2023 and were the subject of specific demands on September 12th, 2024, October 8th, 2024, and October 17th, 2024, which were not disclosed to the defense until months after the court decided our initial motion to dismiss. So they specifically requested communications between Kate, Attorney Mello, and Detective Lieutenant Tully. Mr. Mello forwarded many of the communications relevant to the instant motion to dismiss the indictment to co-counsel Robert Cosgrove on December 16, 2024, but Mr. Cosgrove didn't provide them to defense until July 7, 2025. He had them 7 months. Notwithstanding specific defense demands for the exact evidence addressed to both months before the defense filed the first motion to dismiss the indictment. So just completely ignored the request. On September 4th, 2025, the defense learned for the first time that DL Tully apparently edited and renamed Mr. Kearney's content, and that this altered evidence later became the exhibits used by Mr. Mello and Detective Lieutenant Tully to mislead the grand jury about Mr. Kearney's alleged intent. I don't think he's a lieutenant anymore, if I am correct. I believe he lost his title and he is now just Detective Tully. But I can be wrong, but I'm pretty sure that he lost his title. But it was very hush hush. They didn't like announce it or anything. It was just kind of went into effect, I think. The communications between and among Ms. Peter, Mr. Mello, and DL Tully recently disclosed by the Commonwealth established that the defense still hasn't been provided with a private video with private video links Ms. Peter sent. So the links that Ms. Peter sent to Mello and Tully directly, the ones that she was referencing saying, here he's committing witness intimidation, those links have yet to be provided. Photographs and other evidence Ms. Peter sent to Sergeant Buchanan has not been provided, and communications between Ms. Peter and Tully regarding the assistance she provided Tully immediately before he accessed Mr. Kearney's actual episodes and edited them, changed their names, and placed them in an intent folder he created for use in the grand jury. The DA now claims that numerous private links containing discoverable information about Mr. Kearney that Ms. Peter provided to Mr. Mello and DL Tully has since been deleted by a, quote, private party, meaning Kate Peter deleted them because she was hosting those links. So the Commonwealth has represented that Tully has never opened any unsolicited links emailed to him by Ms. Peter. I believe that is a link to a YouTube video where he states that in court. Yes. So notably, they have not and cannot say the same about Mr. Mello, who not only opened private links sent to him by Ms. Peter, but sent them to Detective Tully for him to review. Do we have a... Hold on. I don't know where that link is. That's why it's redacted. So we don't have whatever it was that Kate sent to Mello with the private links. It's redacted, but the defense has it, so they know more about that than the public at this point. All right, so therefore, favorable and discoverable and evidence that indisputably was in the Commonwealth's actual possession since 2023 apparently is no longer available for disclosure to the defense. That's pretty convenient for the Commonwealth. Mr. Kearney has been prejudiced by the non-disclosure and or destruction of exculpatory and discoverable evidence because the defense has been deprived of critical, substantive, and impeachment evidence in support of the claim that the DA's biased and shoddy investigation relied upon unvetted and possibly tampered evidence from a source with a patently obvious motive to falsely accuse Mr. Kearney and with a track record of doctoring evidence against him on at least 2 occasions. So she's been known to doctor evidence to make Kearney look bad. She has a vendetta against him for whatever reason, and she wants him in prison, as it appears. And she's said it on numerous occasions on YouTube many times. So basically, yeah, you're taking the word of a psycho who has wanted for years to get Kearney in some way or another, and you're taking her word for it. And now that evidence is gone, and we're just supposed to believe that these weren't doctored or edited in any way to make Kearney look bad when she has a track record of doing that. Mr. Mello's communications with DL Tully and Ms. Peter regarding her relationship with and production of evidence to the prosecution, the likelihood that he will contradict Tully's claims that he has never reviewed private links sent by Ms. Peter, his knowledge of Ms. Peter's motive to falsely accuse Mr. Kearney, and her overall lack of credibility, his knowledge that Tully edited and renamed evidence that he later introduced to the grand jury, and his conduct before the grand jury, which included eliciting false and misleading testimony from DL Tully, supports Mr. Kearney's defense and will make Mr. Mello an essential defense witness. So, because of all those reasons, Mello is a witness in the trial. I'm pretty sure the defense will want to call him if allowed by the judge. Mr. Mello also made himself a material witness when, on November 5th, 2023, in his official capacity as Mr. Kearney's prosecutor, he called the police advocating on behalf of witness Chris Albert by seeking to have peaceful protesters assembled across the street from Mr. Albert's pizza shop charged with witness intimidation. If you guys remember that, that was the Canton 9. So there were 9 individuals who were standing outside a busy street. This is like one of the main thoroughfares of Canton where they were standing, and apparently that was too close to Chris Albert's pizza shop, and Ken Mello called Canton police to try to do something about it. If you recall, the Canton police showed up and told them to leave, and then found all of their names by following them to their cars and identifying them and charging them with picketing, witness intimidation type thing. The same thing that they charged Kearney with. All of the charges on the Canton 9 were eventually dropped, but many of them, had to go through proceedings unnecessarily. Mr. Mello's conduct and credibility will be key issue. Oh, and by the way, that exhibit was Ken Mello. It's an audio recording of Ken Mello basically saying, well, can we charge them with anything? And then the officer says, no, they have a right to protest. He calls him back and says, oh, look at this statute over here, the picketing a witness. Can we charge them with that? And that's what that call was. So Mr. Mello's conduct and credibility will be key issues at trial, and it would therefore be improper for him to represent the Commonwealth and defend himself as a sworn witness. Mr. Mello must disqualify pursuant to Rule 3.7, which mandates that a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. And if we look over here, that is exactly what it says. Rule 3.7, lawyer as a witness. The only reason that you can, or the reasons that, like, to exclude disqualification would be testimony relates to an uncontested issue, testimony relates to the nature and value of legal services rendered in the case, or disqualification of the lawyer would work substantial hardship on the client. Those are the only exclusions as to when this rule would not apply, and I don't think that it would apply because the client is the Commonwealth. They can find somebody else to prosecute, or maybe they can't find someone else to prosecute, and that's what the problem is. But they're supposed to be able to show that they can, because remember, the last judge said, I want you to be able to. I'm not going to disqualify Mello, but or not Mello. Mello's out sick or whatever. So Cosgrove's in. He said he's not going to exclude Cosgrove or disqualify Cosgrove from being the attorney in the case for the state. However, if that comes down to he has to give cross-examination or examination of a witness that he's related to in the case, like Lindsay Gattani, he would have to find a different attorney to do that, to sub in for him during that time. That's what the latest ruling from the judge was. So we'll see how that goes. All right, so the court has disqualified Mr. Mello from prosecuting Mr. Kearney in this other docket for the exact same reasons being sought here, which we have Judge Doolin memorandum of decision and order on defendant's motion to DQ Special Assistant District Attorney Ken Mello. The defendant, Aidan Kearney, has been indicted on one count of witness intimidation and one count of unlawful wiretapping. Presently before the court is Kearney's motion to disqualify Special Assistant District Attorney Kenneth Mello from prosecuting this indictment for the following reasons. Kearney's motion is allowed, and it goes on to say, Kearney contends ADA Mello must be disqualified as counsel for the Commonwealth because ADA Mello is communicating with the witness during the time frame the crimes were allegedly committed and made himself a necessary witness. At trial, a prosecutor shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. That's again quoting Rule 3.7. A witness is necessary where the proposed testimony is material and relevant and is also not cumulative and is unattainable elsewhere. You can't get that anywhere else but from Mello. In considering whether to disqualify counsel, a judge must closely scrutinize the facts before him or her to determine whether a lawyer's continued participation as counsel taints the legal system. Here, ADA Mello is receiving communications from a witness while the alleged crimes were being committed, made himself a potential witness in Kearney's case. As such, ADA Mello may very well be called as a witness at trial by Kearney or the Commonwealth to testify to the content of those communications. Therefore, because ADA Mello could be called as a witness at trial, he must be disqualified from prosecuting this particular case. So that was a huge win for Aidan. However, that was only for those couple of charges on that docket, which I believe was the Lindsay Gattani docket. Like those charges related to Lindsay Gattani. Because they said he intimidated her too, I believe. or at least I know the assault, and they claimed that he assaulted her or pushed her on the couch. And then um whatever else, I can't remember. Um all right, back to our document here. So the court disqualified him for the reasons being sought here. Accordingly, for the reasons detailed in this affidavit, its exhibits, and the accompanying memorandum of law, the court should dismiss the indictments against Mr. Kearney and disqualify Mr. Mello, or, in the alternative, order an evidentiary hearing on the motions because the prosecution has prejudiced Mr. Kearney by A, intentionally impairing the integrity of the grand jury proceeding, and B, failing to disclose specifically requested exculpatory and discoverable evidence in their possession, custody, and control, and Mr. Mello's conduct has made him a witness. So Mello's a witness. They're not turning over discovery, and they intentionally misled the grand jury. So those are three big reasons. The need to silence Mr. Kearney. On April 10th, 2023, Ms. McCabe and the Alberts learned that they were subjects of a federal investigation into the Commonwealth's investigation of Mr. O'Keefe's death and its subsequent prosecution of Ms. Reed. On or about April 10th, 2023, Colin Albert was served with a federal grand jury subpoena, which we have here. Walk-in. Bridgewater State University they went to. Entered by Ashley Barone, let them in, I think, on April 10th, 2023. Colin Vincent Albert from Canton, Mass. Male. Victim. What does victim mean? And oh, he's not the victim, I guess, is what that means. No. Matthew Turner. Ashley Barone. Maybe those are the two officers that went. I don't know. What does that say? 906 out with 2 FBI agents at the above location to serve Colin Albert. That was his subpoena where he was served. So Turtleboy reported on that, and that's the receipt that did in fact take place. On information and belief, on the morning of April 10th, 2023, Ms. McCabe was served with a federal grand jury subpoena also, so same day. Sometime thereafter, Brian Albert, Mr. Proctor, Brian Higgins, Carrie Roberts, and others were served with federal grand jury subpoenas. On information and belief, Ms. McCabe was briefly interviewed by FBI agents on the morning of April 10th. As detailed in her testimony, I believe this is a clip to her testimony, Ms. McCabe told at least 2 material lies to the FBI. Ms. McCabe lied to the FBI by initially claiming that she was her sister Nicole Albert before properly identifying herself. Ms. McCabe lied to the FBI about phone calls she made to Brian Albert and Carrie Roberts and others immediately, including Peg O'Keefe, immediately after she was approached by the FBI agents. Although she testified at Ms. Reed's 2025 trial that she was cooperative with law enforcement, Ms. McCabe terminated her FBI interview within minutes. So she claimed she cooperated, but she didn't speak to them for very long. She kept them waiting while she went and made a bunch of calls, came back out, and then abruptly, ended the interview. On April 10th, on information and belief, immediately after Ms. McCabe called Ms. Roberts while FBI agents were waiting to speak with her, a call Ms. McCabe lied to the agents about, Ms. Roberts asked Stephen Nelson, the DA's victim witness advocate, something. And we can't click on it because I believe it is redacted. So whatever this text message is, or email communication, whatever, it's Carrie Roberts communicating with Steve Scanlon about the FBI approaching Jen McCabe. On April 10th at 12:03 p.m., Ms. Roberts and Ms. McCabe, also redacted. Then Ms. Roberts redacted. But we do have a footnote here, which might give us some idea as to what is redacted. So Ms. Roberts did speak to the FBI as revealed in her testimony at Ms. Reed's 2025 trial. She repudiated her 2022 grand jury testimony where she falsely swore that she heard Ms. Reed ask Ms. McCabe to Google "house long to die in cold" sometime after 6 a.m. on January 29th. In 2023, after being read whatever that is, some constitution law warnings. What is that? Let's look. Um, Statements. I can't read that small writing. Statements or entries generally. Except as otherwise provided in this section, whoever in any matter within the jurisdiction of the executive, legislative, or judicial branch of the government of the United States knowingly and willfully falsifies, conceals, or covers up any trick, scheme, or device, a material fact, or devise a material fact, make any materially false, fictitious, or fraudulent statement or representation, or make or use any false writing or document knowing the same to contain a materially false, fictitious, and fraudulent statement or entry, shall be fined under this title. So anyone falsely making false statements to the FBI shall be, not can be, shall be fined under this title, imprisoned not more than 5 years, or if the offense involves international or domestic terrorism as defined in section 2331, imprisoned not more than 8 years, or both. If the matter relates to an offense under Chapter 109A, 109B, 110, or 117, or Section 1591, then the term of imprisonment imposed under the section shall be not more than 8 years. So basically, you can be fined, you could be imprisoned for making these false statements to anyone. It doesn't matter. So it's executive, legislative, or judicial branch. So cops, judges, whoever you knowingly lie to. And I believe this is a federal law, statute, whatever. So don't lie to the feds, basically, is what that says. But if that's the footnote here, then that must mean that Ms. Roberts lied to the feds or in her testimony. Somewhere along the way, she's been lying, as we know that she lied. She said in the grand jury, she falsely swore that she heard Ms. McCabe ask Ms. Reed, or no, that she heard Ms. Reed ask Ms. McCabe to Google "house long to die in cold" that morning at 6:23. She falsely testified to that, and that came out in trial too, that she lied. On April 12th, 2023, just 2 days after Ms. McCabe had been rattled by the FBI, Ms. Reed's defense filed its lengthy motion, which, among other things, alleged that significant and reliable evidence implicated her and Brian Albert in Mr. O'Keefe's death. I don't remember which one this is. Hold on. Okay, so this leads us to Alan Jackson's 92-page affidavit for Brian Albert's phone records again. So this was already linked before, but he's linking to it again to reference it. So Ms. Reed's motion accused Ms. McCabe of Googling "house long to die in the cold" at 2:27 a.m. on January 29th, 2022, and alleged that other data demonstrated that Mr. O'Keefe was inside Brian Albert's home when he died. So not only did she Google that, but the state dog, oh my God, what did he just do? I don't know. My dog did something as I'm recording, and he's always messing me up. Sorry. Okay, so Reed's motion. So what I was saying, so we have the 227 search. Dog, you're going to get a timeout in a minute here. So we have the 2:27 a.m. search, and then we also have forensic data showing us that Brian Albert was likely inside that home. The temperature of the phone, the battery, the and the temperature of the phone, like we got the actual temperatures of the phone. Remember that what came out in trial too, and it never went past a certain temperature, which means he probably was not outside with his phone. So that's some interesting info that came out in trial too. Ms. Reed's defense further alleged that A, it had uncovered significant evidence that Ms. McCabe had taken affirmative steps to delete and tamper with evidence, and B, it had a good faith belief that Brian Albert had taken affirmative steps to destroy evidence. Suffice to say that between April 10th and the 17th, 2023, Ms. McCabe and the Alberts had strong reason to be concerned about their legal situation and the adverse impact of their public reputations that would result from media coverage of scrutiny they received from the FBI and or from the Reed defense's allegations of their complicity in Mr. O'Keefe's death. And we have a fourth footnote here, which says Ms. McCabe was concerned with being publicly associated in any way with Mr. O'Keefe's death. On January 30th at 8:06 a.m., she Googled BPD and John O'Keefe. On January 1st, 2022 at 11:23, she Googled John O'Keefe. On February 2nd, 2023 at 10:54 a.m. in a text message to her daughter, she said something we don't get to know. Wonder what she said to her daughter about the death of John O'Keefe. On February 2nd, 2022 at 11:37 a.m., Ms. McCabe Googled Jennifer McCabe. So she Googled her own name. Despite their concern with being mentioned in the growing media coverage, less than 72 hours after O'Keefe's death, Ms. McCabe and Carrie Roberts, this I believe is when they were talking about who would play them in the movie. Is that a footnote? That's a footnote. Right? Or did I? Oh no, that's redacted. So that's the end of that footnote. So we are whatever they were saying here about Ms. Roberts thinking maybe Sandy Bullock would play her in the made for TV movie. Doubtful, but that's what she says. Okay, on April 18th, 2023, Ms. McCabe and the Alberts' concerns were amplified when Mr. Kearney, citing the publicly filed defense motion and exhibits as his primary source, blew the lid off the Reed case by publishing his first Canton cover-up article. We already looked at that. After Mr. Kearney posted his first story about the Reed case, the DA sought to muzzle him in response to numerous complaints from Ms. McCabe and the Alberts, who had substantial access to and influence with the DA. And we're on now. Footnote number 5. Brian Albert was a longtime Boston police officer who had a personal relationship with Canton Police Chief Ken Berkowitz. His brother Kevin Albert was, and still is, a Canton police officer. In April 2023, Chris Albert had recently been elected to serve as a Canton Town Selectman. Members of the Albert family had a personal relationship with Mr. Proctor. Ms. McCabe had personal relationships with members of the Canton Police Department who were involved in the Reed case. So everybody, it's all incestuous, pretty much. And also, the fact that then Chris Albert becomes a town selectman right after his brother has a dead police officer on his lawn. It's kind of suspicious timing, don't you think? And it also leaves Chris Albert up to, he's a public figure now. Well, they all are at this point, but Chris was really a public figure because he was the Canton Town Selectman. On April 20th, 2023, no doubt concerned about the viral dissemination of Mr. Kearney's article and its detailed exposure of the Reed defense motion, Ms. McCabe something something, and that's redacted. What was Exhibit B? I forget now. Oh, it's not coming up because it's redacted. Okay, on information and belief, in response to Ms. McCabe's comments, that's redacted, which would become a constant refrain, the DA publicly stated it would disprove the Reed defense's allegations about the timing of Ms. McCabe's Google search. Hmm. We have another footnote here. Although the DA literally responded to the April 12th, 2023 defense motion, Ms. McCabe didn't demand that the DA do something until Mr. Kearney's reporting emphasized her Google search and implicated her in the cover up of Mr. O'Keefe's death. The DA's knee jerk defense of Ms. McCabe occurred weeks before it hired a digital forensics expert, which occurred on or after May 7th, 2023, the day DA Morrissey excitedly instructed his team to hire Jessica Hyde because she anticipated an opinion that might support the DA's position on Ms. McCabe's Google search because of a possible time zone issue. And that is exactly what she says in an email to, I think it's Brian Tully. Oh, here's Jen McCabe's Google searches. I forgot to show you that. So here's where she Googles herself on 2/2/2022. She Googles herself. She Googles all this other stuff about John. All right. Here is the Jessica Hyde email. So basically, Brian Tully reaches out to Jessica Hyde and explains the whole situation, and he thinks that they have something wrong with the wall file or whatever. And he says that, he gives her so much information about it, actually. He says that they're alleging a police cover up, and so we're hiring a cell phone data expert outside of our unit because they have experts that can testify for them. So they're asking if someone can testify outside from an outside organization regarding the 227 search. And so that's basically what he tells them. He also says, the witness had told us that the Google search, which she conducted at the request of the defendant shortly after the victim is found dead covered in snow. So she's giving them details. He's giving her all these details about check the Knowledge C database because it says house long to die in cold at 6:35. So go look at that. So he's telling her everything in the first email, basically. She comes back and says, "Hi, I just received your message. How can I help?" He says, happy to help with this. Or she says, sorry, happy to help with this. What kind of image do you have? So I don't know. They must have talked or something on the phone. And then she wants more information about what he has. How does your agency typically engage with outside experts? And then he says, we don't. We have sworn personnel. But given the allegation of corruption, we want to use someone outside, basically. And she says, I have attached our rate. Oh, wait, hold on. Her message goes all the way up here. So, Brian, thanks. With the FFS extraction from Grade Key, we should be in a great place to engage for work. At first glance, this may potentially be a time zone issue in which some data is UTC and some is EDT. However, we won't know until we take a look at the forensic image. We are happy to assist in this matter and conduct the analysis as well as testing and verification to ensure a true understanding of a timeline of the internet search in question and she spelled that wrong, produce a report. We have strong capabilities in the areas of iOS. Okay, blah, blah, blah. I have attached our rates. We have a 25% discount for law enforcement. Here you go. And Brian obviously forwards it to Mello. He says, reference to me by Ed Keefe. She apparently is big in this field with lots of articles. And Morrissey says, hire her immediately. She's probably the only one that's like, yeah, okay, I'll look at it. Doesn't sound fake or bogus to me. So that's that. All right, let's get back to our document. We are not breezing along here because this is a very long document, but we'll get through it. Notwithstanding the DA's attempts to triage the metastasizing scandal by publicly defending Ms. McCabe, things continued to get worse for her and the Alberts by the day. Mr. Kearney's reporting led to Ms. Reed's modestly attended court appearances becoming newsworthy events overflowing with supporters and media. Her support became so great that before both of her trials, the court ordered a buffer zone that a buffer zone be created to prevent jurors from being exposed and influenced by Ms. Reed's vocal supporters. Here's an article about the buffer zone, basically just confirming that the buffer zone was implemented and people could not just go up to the to the to the courthouse. They had to be in that buffer zone if they were going to wear any memorabilia or do any kind of protesting or support of any kind. After April 18th, Ms. Reed's public support increased exponentially. Her growing throng of supporters regularly protested and held standouts, where large groups of people congregated in public spaces and displayed signs of support of Ms. Reed and criticism of the DA, the MSP, McCabe, and the Alberts. On May 9th, 2023, the DA wrote the U.S. Attorney's Office seeking information about the federal investigation after being notified about the issuance of at least 2 federal subpoenas. So that was when Morrissey got the balls to write a letter to Josh Levy, the first assistant United States attorney, about a federal investigation into them, basically. On May 18th, 2023, the DA sought the recusal of the Boston U.S. Attorney's Office from the federal investigation due to what it alleged was a conflict of interest. So then they wrote another letter. On May 24th, 2023, Ms. McCabe and Ms. Roberts clearly worried about Mr. Kearney's growing influence on public opinion. And we don't get to know why. There's some redaction there. On May 30th, 2023, Ms. McCabe unsuccessfully sought a harassment prevention order. Which is pretty funny. We're going to read it really quickly. This was the other letter that Morrissey sent to the assistant, or I'm sorry, the Office of Professional Responsibility, saying that there was a conflict of interest because the former the former AG or whoever didn't like him and was out to get him or something. So that was why the conflict of interest. This is an affidavit of Jen McCabe for a harassment prevention order. Aidan Kearney has been attacking my character through multiple social media platforms and in person. I am currently a witness in the Commonwealth versus Karen Reed. Over the course of the last month and a half, the defendant has harassed me, my husband, my children, my extended family, and my friends. On 5/24/23, Aidan Kearney chased myself, husband, family, and friends out of the courthouse and proceeded to harass and intimidate me, where I feared for my safety. She had to squeeze that in because she forgot to say that and she wanted to make sure that the judge knew she was afraid. Aidan Kearney proceeded to call me a cop killer while videoing the interaction in order to share on his multiple social media platforms. That same day, Mr. Kearney went on his live broadcast where he continued to spread lies and misinformation, once again calling me and my husband cop killers and threatened to make my life hell. He also threatened to come to my children's public events and lacrosse games in order to embarrass me and continue with his vulgar rants. He has repeatedly called me the next Tuesday word. He parked and took live video outside of my house. He threatened he would be back in order to make my life hell. He has posted numerous photos of my minor children over his multiple social media sites, causing fear and anxiety in my children. He is creating and profiting off of t-shirts that he has made in order to humiliate me and my physical appearance. As I have outlined, these incidents of harassment have been going on since April in order to harass, intimidate, and cause fear and anxiety to myself, my family, and friends. Mr. Kearney has said time and time again he will continue to disrespect, embarrass, and make my life miserable, both in person and over social media. This behavior continues on a daily basis, and I feel it will never end. I am asking the court to issue an emergency harassment order to protect the safety of myself and my family. I also have provided a thumb drive showing multiple events of Aidan Kearney's harassment towards me. It does not even look like McCabe there, but I guess that's her handwriting. That says Jen McCabe. So that was her affidavit. A lot of this obviously it's like criticism to her role in the Karen Reed case. So it's open for public debate. So of course the judge rightfully denied it. Demonstrating her fundamental misunderstanding of the First Amendment, Ms. McCabe alleged that on April 18th, 2023, the day he first reported on the Reed defense motion accusing Ms. McCabe of complicity in Mr. O'Keefe's death, Mr. Kearney attacked her character. In what amounted to a request for unconstitutional prior restraint on Mr. Kearney, Ms. McCabe urged the court to do something so he can't blog about me. Can you make him stop writing about me? No, that's called First Amendment rights. The court predictably ruled that, however upsetting Mr. Kearney's reporting made Ms. McCabe, he was a member of the press, and his activity was protected speech under the First Amendment. On July 1st, 2023, Ms. McCabe, who frequently asked the DA and courts to do something about Mr. Kearney, oddly contacted him on Facebook Messenger. And here we have a weird half-naked man that she sends to Kearney on the screen. Don't want to leave it there too long. And then Kearney writes, "Is that Matt?" She says, "Haha, it's your boy." And it's John Como, one of the guys, one of the boots on the ground people. He says, "Who's that?" She says, "Sorry to bother you. Have fun in Mashpee." And then he says, "I'm not in Mashpee, but I'll be in Canton again soon. Are you still fearing? Did you ever figure out how long to die in cold?" And then he sends a picture of Colin being a punk, and she doesn't respond. So that's also an exhibit. John Como's an exhibit now. But if she's so scared of him, then why is she sending him this? This came July 1st, which was after, obviously, the May hearing to get him, right? Was it May? Yeah, May 2023. Same year. So, yes. In what amounted to a request for unconstitutional prior restraint, we read that the court predictably ruled that it was all First Amendment. Ms. McCabe apologized to Mr. Kearney and then ominously advised him to have fun in Mashpee, where Mr. Kearney was vacationing, which suggested she kept tabs on his whereabouts. So, how did she know he was in this town? So, who's intimidating who here? Who is intimidating whom? Or who is intimidating who? I don't know. One of those. On July 13th, 2023, in an email with the subject line redacted, Mr. Proctor emailed DL Tully, Lieutenant Fanning, Sergeant Buchanan, and Reed prosecutor Adam Lawley, referencing Mr. Kearney as something. I think this is when he calls him asshole. Mr. Proctor informed the group of something. We don't know what. On July 16th, 2023, no doubt reeling from the perfect storm created by the ongoing federal investigation, Ms. Reed's aggressive defense, and the public's increasing awareness of the growing scandal resulting from Mr. Kearney's reporting about the Reed case, DA Morrissey, from his personal email address essentially begged the Massachusetts Attorney General's office to prosecute Mr. Kearney for witness intimidation and or civil rights violations. We missed a thing here. So under this statute, it is a crime for a public official to remove or attempt to conceal the discovery of records that are subject to the public inspection under FOIA. What are they hiding? What are they hiding? Where'd that 7 go? Here. So DA Morrissey from his personal email address, because he was using a personal email address, he was attempting to hide anything coming up for a FOIA because it's not his government issued email address that he's using to communicate about it. On July 21st, 2023, DA Morrissey, from his personal email account, again urged the AG to act against Mr. Kearney. On information and belief, the AG declined to prosecute Mr. Kearney because it recognized that it was inappropriate to prosecute him for witness intimidation based upon his reporting about witnesses who were upset after being accused of publicly filed documents of complicity in a high-profile murder. On December 8th, 2023, again from his personal email account, DA Morrissey wrote to Tully and others bemoaning the AG's conclusion that Mr. Kearney's conduct did not warrant criminal prosecution. So they went to the AG and said, we want to prosecute this. And they said, no, it's not worthy of prosecution. But yet they still are continuing on. On July 24th, 2023, Ms. McCabe told Mr. Nelson something. Mr. Nelson is the victim's advocate from the DA's office, who they were in communication with during the trial. On August 1st, 2023, Canton Selectman Chris Albert contacted the DA. And said something. I'm sure it's redacted. Yeah, we can't click on it. Nothing comes up. On August 3rd, 2023, General Counsel for the Department of Justice's Executive Office for U.S. Attorneys rejected the DA's request for the Boston U.S. Attorney's Office to recuse itself from the federal investigation. General Counsel for the Department of Justice, the DOJ, was like, nah, we're not going to recuse ourselves. So for the Boston U.S. Attorney's Office, we're gonna stay on it. On August 9th, 2023, Ms. McCabe something redacted. On information and belief between August 9th, 2023 and August 25th, 2023, Ms. McCabe, members of the Albert family, the MSP, and DA Morrissey and or others met to discuss Ms. Reed's latest demand for the DA to do something to stop Mr. Kearney from reporting about her. On August 25th, 2023, DA Morrissey capitulated to the demands and threats of Ms. McCabe and the Alberts and decided to do something about Mr. Kearney. That something was DA Morrissey's video recorded public statement, which press officer David Traub immediately disseminated to local and national print and media. That is the Morrissey hostage video where he's sitting in front of a bunch of legal books, law books, and saying Colin Albert didn't do it. We gotta stop now with the witness intimidation. Colin Albert didn't do it. Sorry, that's a terrible Boston accent, but you get the point. So prior to issuing this ill-conceived public statement with assistance from Canton Police Chief Helena Rafferty, DA Morrissey accepted input on the content of his statement from a person advocating for Ms. McCabe and the Alberts' interests. Mr. Traub informed the advocates that he sent DA Morrissey's statement to Dateline NBC and numerous other media entries. By issuing a statement on behalf of witnesses with interests that differed from his own, DA Morrissey allowed himself, the elected district attorney, to be exploited as a puppet whose strings were controlled by influential private citizens motivated to advance their self-serving agenda, which included silencing Turtleboy. So he basically let himself be used. That's what that was. By some self-serving assholes that just wanted to silence Turtleboy because it put a bad spotlight on them. Morrissey's statement was flagrant violation of Rule 3.6, which states a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial or an outside of court statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding at the matter in the matter. Sorry. Notwithstanding paragraph A, a lawyer may state the claim, offense, or defense involved and except when prohibited by law, like if there's a court order in place, a gag order, the information contained in the public record, that an investigation of the matter is in progress, the schedule, these are the things you can talk about versus everything else. So you can only talk about the claim, the offense, the defense. Unless there's a gag order, you can't talk about that. You can talk about the things that are in the public record, meaning Aidan reporting on things in the public record is totally legit and legal and not a problem. But for an attorney, you can only say things in the public record. That an investigation of the matter is in progress, scheduling or result may the scheduling or result of any step in litigation. So you can talk about like, well, we have an upcoming hearing. And a request for assistance in obtaining evidence and information if you need to. So if you've got to ask the public for info or whatever, a warning of danger concerning the behavior of a person involved. In a criminal case, in addition to subparagraphs 1 through 6, the identity, residence, occupation, family status, if the accused has not been apprehended, the fact, time, place of arrest, all those. Okay, so really specific things that don't really matter here. So that's Rule 3.6. He basically shouldn't have gone out there and said, Colin Albert didn't do it. The people in that house didn't do it, is what he said. You can't make a statement of fact like that if you're the DA over the case. Although he didn't name Mr. Kearney in his public statement, DA Morrissey took subtle shots at him by attempting to discredit the reliability of information from the internet. DA Morrissey vigorously vouched for the credibility of Ms. McCabe, and the Alberts decried their victimization from Mr. Kearney's witness intimidation, ludicrously decreed that Colin Albert did not commit murder, blatantly misled the public about Mr. Proctor's credibility, discussed the evidence against Ms. Reed, and implied that she was guilty. There is probably just a link to his. Yeah, that's just a YouTube link. We don't want to watch it. We've seen it a bajillion times. Okay, the latest effort by Morrissey to stem the snowballing criticism failed miserably. On September 3rd, 2023, in a group text which included Morrissey, Tully, Buchanan, and others, and Mr. Proctor, Mr. Proctor, referring to Kearney, said the quiet part out loud. And I believe this is where he just says, why don't we just arrest him? Like, we're the big mean baddies. We've got the guns and the badges. We've got control over the prison system. Why don't we just arrest him? Why don't we take away his civil liberties because we don't like what he's saying about us? Crazy. As it turns out, Mr. Proctor's something was prescient or predicting the future. In the aftermath of their futile public statements and after being repeatedly rebuffed by DOJ and the AG, the Commonwealth played its only remaining hand. Shut Mr. Kearney up by prosecuting him itself. So Chris Albert tried to get a witness intimidation thing. That didn't go through. Jen McCabe tried to get tried to get a harassment prevention order. I believe Chris Albert's was first, then McCabe's. Both of them were denied, rightfully so. And so then they start putting pressure on DA Morrissey to arrest Kearney. The Commonwealth unveiled an Orwellian plan in which they, the very people being criticized by Kearney, weaponized the witness intimidation statute for the purpose of silencing his criticism of them. Oh, I missed a footnote at some point. We had a footnote. Where did, oh, no, where did, oh, it was all the way up here. So Proctor, about that text. The court is no doubt aware of Proctor's habit of crudely referring to people adverse to his position. At a minimum, the disgraced former trooper has separately made inappropriate remarks about Ms. Reed, two of her attorneys, and a medical examiner, and now Mr. Kearney. I believe his name for Kearney is just asshole. Here, for this one, the Orwellian plan in which the people being criticized, weaponized the statute to arrest him, to silence him. Within months, the out-of-control Commonwealth's abuse of the witness intimidation statute led it to investigate others with the temerity, he uses big words, to publicly criticize, like the balls, the goal, the people who had the balls to stand up to the government and publicly criticized the case against Miss Reed. The MSP and Canton Police Department summoned podcasters. They did? What is this? Oh, I don't know what this is. Canton 9 CPD police reports. Oh, did they go to like different? No. Sorry, I don't know what this is. I've never seen this before. So it's long. I don't want to read it all. It has to do with the Canton 9 and the picketing statute, but I believe that maybe the law enforcement sought out podcasters. That's what it said. Let me take a really quick peruse of this and I'll get back to you. Okay, so it's the affidavit of one of the officers there. So he was dispatched to the area. He shows up. There's 9 people standing across the street from D&E. Officer Chin, who is one of the officers that arrived with him, recorded the interaction with his cruiser mounted laptop unit. This guy's microphone was activated. The signage of the people was about Karen Reed. They handed out copies of the statute of illegal picketing of a witness, handed to some of the individuals. The picketers were explained that they could not be in view of D&E Pizza and Subs as Chris Albert was inside, who is a named witness in the open case. So to me, that would mean, okay, let's move a little bit down the street so we can't be in his view. But the officers took that to, you must go away and disperse. You can't picket anymore. Officers asked the individuals involved in the picketing for their names due to the offense, but they refused to give that information. After we cleared the scene, Officer Chin and I, who were both in fully marked cruisers, ran license plates of vehicles in the area, including in the nearby parking lot of the restaurant Waterfall Bar and Grill, as well as some of the vehicles in Washington. Officer Chin was able to video record license plates of vehicles parked in nearby parking lots that were subsequently ran and used to determine identities of the individuals involved by comparing driver's license photographs to the video footage of the incident taken by Officer Chin. They went around and grabbed license plates of all of those cars in the area just to find out who those people were, to run their plates and compare it to the footage. How many hours of wasted taxpayer dollars was that to go through all that footage? So this was, or all those license plates, I should say. This was done in an attempt to identify the individuals involved because they didn't want to give their information, which they don't have to. So you didn't need to go and do all that. I feel like that's a violation that they went and did all that to try to find who they were. Officer Chin downloaded the video, took it to the cruiser, blah, 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 blah. It's in the evidence for the case. This guy ran 3 license plates, which were parked near the waterfall. He found Nick Rocco, Deanna Corby, and Meredith O'Neill, who were 3 of the Canton 9. Um, describes their clothing and things like that, and what they were wearing. Someone had a sweatshirt that said "Free Turtleboy." Another was holding a sign that said "Free Karen Reed." Who cares? I spoke with Albert inside of the restaurant. He informed me that several individuals were out on the sidewalk in front of the restaurant near the entrance while holding signs and chanting. When Albert opened the door, he stated that he could hear them screaming. He then stated that an individual put the sign onto the window on his restaurant and that said, Colin Albert was inside the house. Albert stated the individual was approximately 20 years old with light blonde hair, and Albert was able to videotape him. He was later identified as he was the minor in the case. There was one individual who was under 18. I think he was 17 or something at the time. Colin Albert is the son of Chris Albert. So that's how that happened. All right. So Albert mentioned another individual he knew was holding a sign named Jenna Rocco. He states that she runs everything for Turtleboy. Not anymore. Albert also mentioned a blonde female that came close to the window and kept saying that Colin was in the house. That might have been Meredith. He stated this individual, I don't know. Yeah, that individual was Meredith. Okay, who cares? Like, this is not illegal. This is not anything. This is so stupid. It still doesn't say anything about podcasters, though. So I don't know where that statement came from. That's what I was trying to clear up. Publicly criticized. Da, 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 da. The MSP and Canton police summonsed protesters outside. Oh, summons them. That was just the police report. That was saying, what was I looking for? I don't know. My brain has ADHD, so I'm stupid sometimes, so I apologize. So the cops basically, after all of that, that was just to say that they went through all that work, I guess, to find out the individuals that were on the street peacefully protesting and not doing anything illegal, just to summons them in front of a magistrate to eventually have all of their charges dropped. In what became a national embarrassment, they sought witness intimidation charges against people who placed tiny rubber ducks. I can't remember his name now. The one guy that did that. It's escaping me. But they put in more investigative work into the mini rubber ducks that were being left around Canton than they did in John O'Keefe's actual murder. They investigated people for the content of Facebook messages, which were critical of the McCabe and Alberts. This colossal waste of public resources didn't result in a single conviction. Yeah, his charges, the rubber ducky charges, were dropped eventually. Rich Schaefer, I think is his name. Rich Schaefer or something, maybe. On September 15th, 2023, in connection with Ms. Reed's court appearance, Mr. Kearney and a large group of her supporters loudly protested outside of the Dedham courthouse in support of her innocence. On September 18th, 2023, Ms. McCabe again informed Mr. Nelson something. And it's redacted, so we can't see it. Ms. McCabe wanted to meet with the DA about something that we can't find out. In fact, what occurred, redacted, the September 15th, 2023 court appearance was official business, redacted, Ms. Reed's case in the courtroom, and redacted the appearance. Protesters exercised their First Amendment rights to criticize Ms. McCabe for her alleged involvement in a cover up of Mr. O'Keefe's death. On September 20th, 2023, Ms. McCabe again told Mr. Nelson something. Mr. Nelson assured Ms. McCabe something. The hell are they talking about? On September 26th, 2023, D.A. Morrissey recused his office and engaged Mr. Mello. That was it's a email saying he's approved or whatever. Lynn Bleland, what? Lynn Bleland's on here? Deb Leahy? Talking about his rates, Ken Mello's rates. Lynn Beeland approves it. And then this other person says, we'll be preparing an electronic contract for him. So that's when they hired him, which was around September 2023. Moving on. Although the DA's recusal indicated DA Morrissey's appreciation for the clear conflict that would arise from the office's prosecution of a journalist who criticized the DA, the MSP, which faced the exact same conflict, didn't recuse itself from the Kearney investigation. DL Tully, a frequent target of Mr. Kearney's criticism, remained the lead investigator. Proctor, who recently had referred to Mr. Kearney as something and something, and Sergeant Buchanan, also regular targets of Mr. Kearney, continued to participate in the investigation and later became named victims in the indictments against him. Footnote here, Mr. Proctor and Sergeant Buchanan testified that they were intimidated by Mr. Kearney. Both indictments were dismissed by the court on May 19th, 2025. In particular, the dismissed indictment related to Buchanan illustrates the Commonwealth's lack of good faith in prosecuting Mr. Kearney. That charge involved a September 15th, 2023 video recorded incident in which Mr. Kearney questioned and then criticized Sergeant Buchanan as he left court and walked to his car. It is obvious that Sergeant Buchanan wasn't intimidated. He calmly entered his vehicle, rolled the window down, and extended his middle finger as he slowly drove away. Nevertheless, Sergeant Buchanan testified that Mr. Kearney's conduct absolutely intimidated him. December 14th, 2023 transcript. Sergeant Buchanan didn't even prepare a report on this non-incident until November 2nd, 2023, several weeks after Mr. Kearney had been arrested. Without more, the MSP's failure to recuse itself and the DA's failure to insist on it in the face of such a blatant conflict of interest and actual bias calls into question the motivation of the Commonwealth and entirely discredits the case against Mr. Kearney. On September 28, 2023, Chris Albert unsuccessfully filed a petition for harassment. Okay, so his was second. That's when he filed the harassment. Oh, this is his affidavit. He says, I believe the police have kept copies of said videos. What? Oh, this is stuff that Aidan Kearney highlighted, I think. This is Chris Albert's affidavit of what he was afraid of. Called him Chicken Parm Charlie. He's afraid of being called Chicken Parm Charlie. He doesn't like that. The court denied Mr. Albert an order, concluding that his allegations did not constitute true threats or harassment under the law. Notwithstanding his supposed recusal from the Kearney investigation on September 29, 2023, DA Morrissey, from his personal email account, not his government issued, contacted several high-ranking Massachusetts judicial figures, including the judge who denied Mr. Albert a protective order the previous day. You get what's happening, Mr. Morrissey, Michael Morrissey, the DA, sent an email from his private account to a judge, the judge who denied Chris Albert's HPO. I don't think that should be allowed. Did I finish my sentence? The court denied Mr. Albert. Okay. No, I just stopped in the middle of a sentence like I always do. So D.M. Morrissey, from his personal account, contacted several high-ranking Massachusetts judicial figures, including the judge who denied Mr. Albert a protective order the previous day, demanding that a Stoughton court clerk be investigated. A Stoughton court clerk um, be investigated in connection with Mr. Kearney's awareness of Mr. Albert's application for a protective order, which D.A. Morrissey claimed he had no right to know about. It's a public document. It was a public court hearing. And this is Michael Morrissey's email to a judge and some other people. I don't know who all these people are, but these are all government emails. Stacy Fortes, Thomas Ambrosino, Philip McHugh, Daniel O'Malley, Lynn Beeland. Dear Judge Fortes, I am writing to express my grave concern with actions taken by an individual employed at the Stoughton District in regard to an affidavit that was shared with a blogger writing about an ongoing second-degree murder case. On 9/28/23, a witness in the Commonwealth versus Reed, and he spelled it wrong, murder case, filed that's important for FOIA requests. He spells Reed wrong and he's using his own personal account. He filed a request for an application for Chris Albert filed the request for an application for harassment prevention order, which was heard before Judge O'Malley. The application and affidavit were processed in the Civil Clerk Department of Stoughton District Court and presented to the judge, which, after hearing, was denied. We were informed by the witness and others that shortly after the hearing that Aidan Kearney, aka Turtleboy, was provided with a copy of the entire affidavit. There is no way that he would have been aware of the proceeding without an insider working in the courthouse. The leading individual who presents as a possible leak is Michelle Littlefield. I know it's late, but I'm horrified that Chris didn't get it. This is Jen McCabe's text to Morrissey, I believe. I know it's late, but I am horrified that Chris didn't get it, his HPO. And I am even more disgusted that for the second time, someone from the court leaked it right away to TB. Then, because the people who work in Stoughton District like me more than him, they sent this humiliating affidavit. This is Turtleboy's words here. They sent this humiliating affidavit to me so that we could shame him some more. We have put in a request for the court audio, and hopefully, with a little luck, we'll have it on the live show on Sunday. So that was a comment by Turtleboy that she sent to Morrissey. Oh, what is this? This is another email? It's just continuation of the prior, I think. Something about Turtleboy are attached. It's clear from the postings that Stoughton Court is directly involved in this dissemination of information. I need this bigger. On murder prosecution. Affecting our murder prosecution, sorry. From the comments from one of the witnesses, you can see that they have completely lost all confidence in the courts of the Commonwealth. That was Jen McCabe's comment. I have to agree that the actions erode the trust and integrity between the courts and the public and the relationship with the district attorney's office. We are extremely concerned that the improperly disseminated court material unsolicited to a third party, which is continuing to cause harm and damage to a witness in an ongoing homicide prosecution, must be a violation of court policies or a potential violation of law. We also understand that Aidan Kearney had also immediately requested copies of the FTR recording that was made on 9/8/23. Again, there is no way that he would have known that he would have or should have known that this hearing took place. There are a number of concerns that we have about the possibility of having to file ongoing motions or other requests for warrant because before this court that will affect the orderly and fair administration of justice. These actions are completely unacceptable and must be resolved immediately. I understand that you do or that you have to do an investigation, and that may take time, but you also have to provide us with some evidence and assurance that you have taken action so that we can safely continue to use the clerk's office of Stoughton District Court. We have a number of delicate matters before them on a day-to-day basis. I await your advice. I feel like this is a threat. Did this judge ever respond? What was the response to this? Were there more communications that came out? I wonder. This seems like a threat to me. Like, well, we need to make sure that we can trust you. I understand that you do have an investigation and that may take time, but you also have to provide us with some evidence and assurance that you have taken action so that we can safely continue to use the clerk's office there. You need to provide us with some kind of assurance. That just shows you what kind of a bully he is. DA Morrissey was awarded the investigation he sought. On October 31st, 2023, 3 weeks after Kearney's phones were seized by Tully, a Stoughton court official presented the target of the investigation with pages from an extraction report from one of Mr. Kearney's seized phones. And that's nearly impossible to read. I can't see that. But this is a communication between, or a cell report between Michelle Littlefield, and her. Something about you can now message me and call each other and see info, active status, and when you read messages. Yeah, something. Did you get a copy of the affidavit? This is, I guess, him or her communicating to him. Not really sure which. To Clarence Woods Emerson, that's Turtleboy. Scott Rodriguez must be the name that her phone's under or whatever. All right. So, despite irrefutable proof that at least one of Kearney's phones had been extracted by Lieutenant Tully, or with his knowledge, Mr. Mello falsely represented on on November 28th, 2023, that the MSP had not pursued the material. It is in pristine form located in the defendant's devices. So they have stated they didn't go searching through his phones. That Exhibit S was, I think that's just a link to Mello saying we didn't touch his stuff. We haven't looked at anything, even though that's a complete lie. On November 10th, 2023, recused DA Morrissey from his personal email account emailed AG Andrea Campbell. He acknowledged that the AG refused to prosecute Mr. Kearney, but he again urged the AG to take some action against him. This is a letter to the AG. And Andrea Campbell. We had a conversation about the potential of your civil rights division at civil rights violations as a result of Turtleboy in an ongoing state murder case. I had asked your office to take a look at both the criminal and civil rights violations. I know there was a reluctance on the part of your criminal division. So there was a reluctance on the part of your criminal division to bring charges against Turtleboy, but we expected to hear if there was an interest in bringing a civil rights violation. The enclosed decision clearly sets forth the basis for civil rights violations. I call your attention specifically to pages 17 through 19. The language on 19 sets forth a strong argument for civil rights violation, including the last sentence in the paragraph that states, the right to a fair trial is just as important to the functioning of democracy as the First Amendment. I thought this would be an important opportunity for the Commonwealth's chief prosecutor and protector of civil rights to be able to step in and stand up for the rights of witnesses, especially in light of the court recognizing, notwithstanding the fundamental importance of news gathering and reporting, the First Amendment does not supersede the proper administration of justice and the court's obligation to ensure a fair trial, including protected witnesses from intimidation. I look forward to hearing from your office. Kind of inappropriate, all these things that Morrissey's doing just to silence Turtleboy because he's critical of his office. Once again, the AG declined to prosecute or take any action against Kearney. Ms. Peter's history of dishonesty and fraud. As Peter worked for Mr. Kearney from September 2018 until February 2020, when Mr. Kearney terminated her employment after he caught her stealing from him. Since Mr. Kearney terminated her, Ms. Peter's unhealthy fixation on needling Mr. Kearney seemingly has dominated her life. It recently resulted in her being permanently stained with a criminal record. This is her guilty plea to something. Not really sure. Guilty plea. Amend to threatening to commit crime. So she threatened to commit a crime. I don't know what that means. Or what it was, what that was in relation to, and I can't read that. It says waiver something before clerk. I think something hearing before clerk. 7/1/2025. I don't remember what that was for. She had a bunch of different issues going on, lots of people getting harassment prevention orders against her. Aidan has one that's been long going for several years, ongoing. So she's a problem. She's been a problem, and she has a record of being a problem. Yet they're using her as their one and only witness to basically come up with the witness intimidation stuff, or as a source, I should say. She's not a witness. She's the source of information. So Ms. Peters' behavior has resulted in additional criminal prosecutions and the issuance of numerous protective orders against her in favor of Mr. Kearney and others associated with him. Ms. Peters' disdain for Mr. Kearney has led her to engage in fraud, forgery, and manufacturing of evidence and other acts of dishonesty for the purpose of harming Mr. Kearney. In March 2020, shortly after Mr. Kearney fired her for theft, Ms. Peter engaged in a harebrained scheme where she forged documents and fraudulently filed them to advance her position and harm Mr. Kearney in connection with a petty YouTube copyright dispute. Ms. Peter brazenly sent YouTube what she falsely represented was a federal copyright civil complaint dated March 24th, 2020, that she filed in the District of Massachusetts in a quote-unquote case she captioned Katherine Peter versus Aidan Kearney, Worcester Digital Marketing LLC. And there is an exhibit for that. Only problem is, this is a forgery. In fact, the ostensible complaint Ms. Peter filed was a forgery, and there was no federal lawsuit involving Mr. Kearney and Ms. Peter. Unaware of Ms. Peter's dishonest nature and penchant for scheming against Mr. Kearney, YouTube relied upon her fraudulent documents and falsely represented to her benefit and false representations to her benefit and Mr. Kearney's detriment, and initially ruled in her favor. So there is the copyright strike that Aidan initially received for the false stuff that she filed. Ms. Peter committed fraud by going online and accessing a legitimate civil complaint filed in a 2013 federal copyright suit from the District of Massachusetts. She altered the caption and other information to make it appear as if her fraudulent documents were authentic and represented it as a legitimate complaint and filed it with YouTube. The fact that she could do that so easily and so carefree, and like she probably brags about it and thinks it's funny to this day, I would think, knowing her personality. Here is the actual filing. So here's Kate. Whoops, there's Kate's filing. She just basically changed some names and took some stuff off. And otherwise, it's the same thing. She'd forgot to change the docket number or something. I don't know how they found her. So I think it was because she didn't change the docket number. So Ms. Peters' criminal scheme was exposed by her ignorance of federal court practice. She failed to change the index number when she doctored the legitimate complaint, which meant that her ostensible 2020 complaint contained a 2013 index number. So that's how they caught her, the index number. Which on November 20th, 2022, in an online interview, Ms. Peter admitted that she submitted the forged complaint with the intent to defraud YouTube because she hated Mr. Kearney. I mean, how she continues to get away with stuff and like charges haven't been pressed and she's not criminally charged for the things that she's done against Kearney. The only thing that's protecting her is that she's an informant for the Commonwealth of Massachusetts. That's the only thing stopping them from like being able to really charge her. She should be in jail. Despite engaging in a dishonest scheme, Ms. Peter reasoned that she was trustworthy because she admitted her wrongdoing. Ms. Peter remained subject to prosecution in Massachusetts for forgery until March 24th, 2026. And of course, that's today as I record this, yesterday to you as you hear this, most likely. Well, depending on when you listen. So this is the statute 267 chapter 5 or whatever that little, does anybody know what that little doohickey is? I don't know how you say that. I'm not a law student. I would love to learn. Anyways, so uttering false or forged records, deeds, or other writings. Whoever with intent to injure or defraud utters and publishes publishes as true a false, forged, or altered record, deed, instrument, or other writing mentioned in the four preceding sections, knowing the same to be false, forged, or altered, shall be punished by imprisonment in the state prison for not more than 10 years, and for not more than 2. Wait, what? For not more than 10 years or in a jail. Oh, prison for 10, jail for 2. You can go to county for 2, state for 10, depending on what kind of criminal you are. So that could be her punishment and why she hasn't been charged and all that, because Norfolk County DA's office is protecting her because she's an informant. Ms. Peters' self-serving defense of her trustworthiness didn't last long. Within months, she again succumbed to an impulsive urge to harm Mr. Kearney and sent him an anonymous email filled with defamatory and false information about Colin Albert and Chris Albert, hoping that Mr. Kearney would publicly harass the Alberts with the false information she fed him. That was the email that she went by Mia Rose or whatever and told him all about the drug dealing that Colin was allegedly doing. Ms. Peter was acutely aware that if Mr. Kearney publicly accused Colin Albert and Chris Albert of criminal activity, it likely would lead these Reed case witnesses to claim that Mr. Kearney was witness intimidating them by causing them emotional harm. Another footnote here. In March 2025, Chris Albert and Chris Albert's complaints did result in further witness intimidation charges against Mr. Kearney. According to the Alberts, they suffered emotional harm after they viewed D&E camera footage. I just laugh because how can you be a man and say that you were scared of dinosaur arms? They viewed the D&E camera footage of Mr. Kearney, who had been socializing with friends next door at C.F. McCarthy's, clowning around while looking at D&E's security camera. Mr. Kearney's comments were unlawfully intercepted by a second camera. So he was illegally recorded, illegally wiretapped, as they say, by Chris Albert with another camera. So where's that charge? You gonna charge Chris Albert for wiretapping? Sure, no, right? Because he's a town selectman. The Alberts claimed they were intimidated even though they weren't inside D&E and viewed the footage on their phones from a different location. They were so scared. Turtleboy's so scary when he does dinosaur arms with Will the Glare. On May 28th, 2023, at 3:30 p.m., concealing her identity under the alias Mia Rose, Ms. Peter shamelessly emailed Mr. Kearney that Callan Albert was a drug dealer and that he was responsible for killing Mr. O'Keefe. Ms. Peter lied to Mr. Kearney that Chris Albert knew his son moved drugs through D&E Pizza. Wait, she lied stating that Chris Albert knew that his son was moving drugs through the D&E Pizza and that the whole Albert family made money from Colin's drug operation, which probably explained why Brian Albert covered up Mr. O'Keefe's death. We read that already. Ms. Peters' deranged scheme, including presenting Mr. Kearney with fabricated screenshots she created and which purported to show Mia and Colin discussing drug deals. That was the I believe the text message that she had attached. Yeah, the do you need any pure? Something about all these different kinds of things. We read that. The sour diesel, the pure and skunk, whatever, talking about drugs, obviously. Um, so that was another fraudulent thing that she created to make it look like Colin Albert and this Mia were talking about buying drugs. Miss Peter falsely told Mr. Kearney that Colin Albert talked about harming John because he believed Mr. O'Keefe was investigating his drug dealing. Just as Ms. Peter intended during his May 28, 2023 live show, Mr. Kearney told his audience that he had received an anonymous email alleging that Colin Albert was a drug dealer and this served as a possible motive for him to kill Mr. O'Keefe. Mr. Kearney read the email Ms. Peter sent him and indicated that he would investigate this information further. He cautioned his audience that this was new, unvetted information and he did not vouch for its accuracy or state that it was true. Importantly, after investigating, Mr. Kearney later stated this information was not credible. On May 29, 2023, during her own live stream, Ms. Peter gloated about her disgraceful conduct, which she oddly thought harmed Mr. Kearney and made her look good. Amused by her little fib, she proudly admitted that the defamatory and false information she provided Mr. Kearney about the Alberts was 100% a fabrication out of my mind. Ms. Peter conceded that her conduct was damaging to Colin Albert and Chris Albert, but rationalized it because I sent this just to fuck with Aidan. Ms. Peter threatened Ms. Kearney, warning him that he should fear her. She issued a call to arms and urged her trolls to send Mr. Kearney more false information, which she would then share with his alleged victims. She bragged, quote, I know that bad things are happening to you right now, Aidan, and you're probably thinking that it might be me, but it's me. Just so you know, every single annoyance, every single horrible thing that's happening to you right now, yeah, I've done it. Call the police, you bitch. She seems so pleasant, doesn't she? In other words, just as she did in her 2020 YouTube spat with Mr. Kearney, Ms. Peter demonstrated the ease with which she lies and, in this instance, intentionally caused emotional harm to prosecution witnesses if it helps her fuck with Aidan. Ms. Peters' defamatory stunt apparently did cause emotional harm to Colin and Chris Albert. On August 1st, 2023, Colin Albert specifically cited something something when he wrote the DA something. And it's redacted, so we can't click on it. Nothing pops up when you click on it. Just as Ms. Peter intended, Mr. Albert assuredly blamed Mr. Kearney for the bogus drug dealing allegations, entirely ignorant to the fact that it was his supporter and advocate, Ms. Peter, who saw him and his son as expendable collateral damage for her false flag operation to harm Mr. Kearney. Within weeks of Miss Peter's cruel and defamatory attempt to amuse herself at the expense of the Alberts and her call to arms unleashing her trolls on Mr. Kearney, Tully and Mello willingly relied on her as a primary source for gathering evidence to use during the grand jury proceedings against Mr. Kearney. Yikes. Sounds like their informant, their source of information is not reliable. Not only is she not reliable, she has a known history of making up false evidence to support her lies. She has no remorse or regard for others when she makes up these lies, as you can see. And she has no remorse at all. She has a complete bias in wanting to take Carney out, like in any way possible. So Miss Peter immerses herself into the case. On information and belief, for years, Miss Peter has spent several hours a week online monitoring and cataloging Mr. Kearney's content, mining for material to use against him. Miss Peter had no public interest or stake in the Reed case and no association with any witnesses in it until Mr. Kearney began supporting Ms. Reed's innocence. Naturally, once Mr. Kearney started to support Ms. Reed, Ms. Peter became a self styled advocate for Ms. Reed, the Alberts, and the O'Keefes, and sought to foster relationships of convenience with others who hated him, including Lindsay Gattani, who shortly after meeting Ms. Peter became the alleged victim in the 2024 witness intimidation indictment against Mr. Kearney. So we have two footnotes we can read at a time because it was all one sentence. In July 2023, Ms. Peter created a Facebook group called Support for MAOs, McCabe's, Alberts, and O'Keefe's. At one point, Ms. Peter volunteered to help members of the group find an attorney to deal with Aidan. And we have an exhibit here. Where does it say to deal with Aidan? Oh, here. I'm not gonna read all that. She's such a lengthy person, but she's saying that he's got crazy defamatory statements. He visits uh, he's victimizing the witnesses, home visits, um, defamatory statements, police disruption, borderline stalking. That's what she's saying he's doing, which is bogus, but okay. And then the second footnote says nothing encapsulates Turtleboy derangement syndrome. We have a footnote here or a link here that says Turtleboy derangement syndrome. So they go from fan to hate. They like Turtleboy. They say to the Commonwealth, stop lying. And then they say, Karen Reed, rot in jail. Free Karen Reed. And then she says guilty. So all these are three examples of people who have switched sides, the antis, as we call them now. Although Lindsay is not an anti anymore. If you follow her on X, she has completely done a 180 again. She's still on the Karen Reed is innocent trail or train, I think, and she's taken down everybody that tried to mess with her, tried to get her to lie about Aidan and get charges on Aidan incorrectly. So nothing encapsulates Turtleboy derangement syndrome, an affliction which causes people to turn on Mr. Kearney, including Ms. Katani, to engage in irrational behavior more than the several people who protested in support of Ms. Reed's innocence and then flippantly switched sides and protested for her conviction solely because of their hatred of Mr. Kearney. After she accused Mr. Kearney of intimidating her, Ms. Gattani became such a rabid advocate for Ms. Reed's guilt on July 1st, 2024, clad in the same Justice for John O'Keefe shirts as Ms. Peter. She appeared with Ms. Peter on a live interview. There's a link to that with Court TV there. On September 13th, 2023, at 3:34 p.m., Ms. Peter publicly bragged that she had archived a purportedly illegal recording made by the retard, Mr. Kearney, of his conversation with Stephen Scanlon, a private investigator who was tangentially involved in the Reed case. And there is the recording here. Is this a video or? Oh no, this is her text saying that she has it. She has the recording. Ms. Peter claimed that she forwarded the recording to the MSP. On information and belief, on September 13th at 4:23 p.m., Ms. Peter created a version of the recording and sent it to Tully in a private link. Here's an exhibit. What is this? An MP3. This is the Scanlon recording that she downloaded. So it's proof that she sent it to to Tully with a private link. November 28th, 2023 transcript says that. Okay, so Tully testified he had been sent a video of the Scanlon recording at 19. DL Tully testified the person who it was sent to, she stated it was a private link, so it was not available for public distribution. She stated, Kate Peter stated it was a private link. That's your source. An audio copy of the recording that Ms. Peters sent the MSP on or about September 13th, 2023, the substance of which was played as a video before the grand jury, wasn't provided to the defense until August 8th, 2025. I don't know why that's taking so long. Oh, that's the actual recording. Okay, the version of the recording provided to the defense doesn't include the beginning of the recorded call, where he says, I'm recording this, just so you know, and skips and repeats. So she edited it out. It was clearly edited. The defense hasn't been provided with a copy of the email or any communication in which Ms. Peter provided the Scanlon recording to the MSP. So they didn't even tell them that Kate Peter is the one who provided it. On September 27th, 2023, Ms. Peter emailed Buchanan something. It's redacted, so we can't see it. The email Ms. Peter sent Buchanan included something which haven't been provided to the defense. One day, after Mr. Mello was engaged by D.A. Morrissey, Sergeant Buchanan confirmed to Ms. Peter that something, again redacted, either ignorant or dismissive of Ms. Peter's own criminal conduct and woeful credibility, Sergeant Buchanan praised Ms. Peter, thanking her. So there's something here telling her what a great person she is. On September 29th, 2023, at 9:38 a.m., Ms. Peter, now on a first name basis with Sergeant Buchanan, emailed Yuri. And it's redacted. Peter provided Buchanan with something. Peter told Buchanan that she was something. Here we have a footnote. So maybe we get some idea or clues. Based upon the information provided to them by somebody, redacted, Tully and Mello's investigators went to Gardena, California to interview Natalie Berschneider in person. So that was their mistake because all she did was talk and talk and talk. On September 29th, 2023, at 3 p.m., Ms. Peter tweeted October 10th, he knows the deal, in response to another's post asking her when Mr. Kearney will be subpoenaed. On information belief, Ms. Peters' reference to the he knows the deal indicates that the MSP told her several weeks before Mr. Kearney's arrest that they intended to arrest him on October 10th. This was September, October. And here is her tweet. October 10th, he knows the deal. Still waiting on that subpoena any day now was this person's response or repost of something else that she sent. She's this masshole mafia. And then she wrote October 10th. Continuing on September 29th, 2023, at 4 p.m., Sergeant Buchanan forwarded his email correspondence of September 27th and 29th with Miss Peter to somebody, and it's redacted. On October 3rd, 2023, Tully emailed Lieutenant Fanning, Sergeant Buchanan, and Proctor that he had blank. Sergeant Buchanan replied that he already provided blank and blank to blank. Lieutenant Fanning replied that all his blank. On information and belief, the blank and blank being discussed by Tully, Sergeant Buchanan, and Fanning on October 3rd, 2023, related to blank, Ms. Peter provided DL Tully in a private link on or about September 13th, 2023, and which was later used against Mr. Kearney in a grand jury. Almost 2 years later, and despite numerous specific demands related to Ms. Peters' relationship with the Commonwealth, the defense hasn't been provided with any notes, reports, or videos related to Ms. Peter or the private link she sent Tully on September 13th. So they're hiding this secretive informant relationship that they have with Kate, even though it's not a secret, but they're not providing any of the discovery regarding it. For months prior to the November 28th, 2023 commencement of the grand jury proceeding, Tully, Sergeant Buchanan, and Proctor were aware of Miss Peters' unstable obsession with Mr. Kearney. As experienced detectives who had been investigating Mr. Kearney since mid-2023, MSP knew or should have known of numerous red flags which adversely impacted Ms. Peters' credibility, including her eager insertion of herself into their investigation, her personal animus towards Mr. Kearney, her hatred towards him, which gave her a clear motive to falsely accuse him of the crime, her insertion into Ms. McCabe's orbit, and more importantly, her prior history of falsifying evidence against Mr. Kearney. Indeed, given their constant review of social media as the means of acquiring evidence against Mr. Kearney, the DA and MSP must have been familiar with Mr. Kearney's March 30th, 2022 or 2020 article detailing Ms. Peters' fraud. So that's where we talked about that earlier. That's his article where he explains the whole fraudulent um, filing that she created. Mm, 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 so the article that was the article detailing Peter's fraud in connection with the YouTube copyright dispute and Peter's May 29, 2023 live stream where she admitted falsifying evidence about Colin and Chris to goad Mr. Kearney into smearing them. Mr. Kearney was arrested on October 11th, 2023, just one day after Ms. Peter publicly announced weeks earlier. So she said October 10th. He was he was arrested on the 11th. MSP audio transmissions from immediately before Mr. Kearney's arrest reveal that the arrest team, a fugitive unit which included Tully, heard from KP. It was the same thing from yesterday, two older kids getting on or around the same time, but it was 8:30. So did KP stalk him to find out when his kids got on the bus? That's what I think. I think KP was maybe stalking him in the mornings to find out his morning routine. On information belief, KP referred to Ms. Peter, Kate Peter, and she helped the MSP coordinate Mr. Kearney's arrest by monitoring them beforehand. Ms. Peter has a history of surveilling people to create chaos for them. She and Ms. Gattani discussed spying on Ms. Reed and members of her legal team at the Omni Seaport Hotel in Boston. She also has shared surreptitious photos, or taken in secret photos, of Mr. Kearney and others socializing at the Hillside Pub in Canton on May 4th, 2025. So she has a history of stalking people. Ms. Peter, why do I keep doing that? It's nothing alike. Ms. Peter attended Mr. Kearney's October 11th, 2023 arraignment in Stoughton District Court. She has testified that she went to meet with Mr. Mello and that she was a potential witness against Mr. Kearney. That's a YouTube clip where she says that. Shortly after Mr. Kearney's arrest, Ms. Peter, with the blessing of Mr. Mello and Detective Tully, became an integral part of the prosecution team. She's basically, yeah, she's a part of the prosecution team, and she hates Kearney more than life itself. And she's going to do anything in her power to try to get him arrested, even if that means falsifying things, editing things to make him look worse or make him look bad, whatever. On October 25th, 2023, Ms. Peter emailed DL Tully that she and her team were something. To this day, the DA hasn't informed the defense who, if anyone, served on Ms. Peter's team. Her and the team. Who's her team? What's the team consist of? Or who, I should say, does the team consist of? Who's she working with that Tully knows about? Ms. Peter sent Tully a blank, which she blank. Wherever she believed there was evidence of crime, she advised Tully something. Ms. Peter further informed Tully that her team had blank. Almost 2 years later, the defense hasn't been provided with information Ms. Peter provided to Tully in the blank or blank links. On November 1st, 2023, Ms. Peter emailed DL Tully with the subject line blank. She informed Tully of blank. Ms. Peter told Tully that she would blank. Ms. Peter's email provided Tully with another link to a blank. Seems like they need all of Kate Peters' emails, all of Tully's emails, all of Buchanan Proctor's, Mello's, I would say at this point, Cosgrove's, and any communications with these individuals with Ms. Peter or about Ms. Peter should be disclosed. And Morrissey, of course. Those should be disclosed. And Adam Lally, because I thought she was emailing him too at one point. Ms. Peter emailed Tully with another link to something. Almost 2 years later, the defense hasn't been provided with the video file and any response by Tully to Ms. Peter's question. She asked a question and he didn't respond. We didn't get the response. On November 17th, 2023, Ms. Peter emailed Tully something. According to Tully, he replied upon information Ms. Peter provided him before he edited Mr. Kearney's YouTube episodes. What? Affidavit of Courtney Healy. Oh, this is talking about Tully is the one that said he filed. I meant to show this to you guys earlier, but I forgot. This is where basically this is a Courtney Healy is on the defense team. She's assisting. I don't know what her role is, her title is, but she's assisting the defense team of Aidan Kearney, and she's she's affirming in this affidavit that Tully told her he's the one that put the file in of intent. He named the intent file because when presenting to the grand jury, it is necessary to provide the intent of the defendant. So he said he named it intent because he wanted to show intent. So therefore, you have the investigator, the lead investigator in Aidan Kearney's case, saying, I wanted to show the defendant's intent by titling a folder intent and showing clips, highly edited and curated clips for intent. On November 26, 2023, just 2 days before Mr. Mello commenced the grand jury presentation, Ms. Peter emailed him, subject line something and something. Ms. Peter sought Mr. Mello's something, writing something. On November 26, 2023, Mr. Mello's response to Ms. Peter proved that he opened private links sent to him. And of course, we can't see what this is because it is a redacted portion of evidence. All right. In response to Mello's request, Miss Peter sent him blank. So they're just going back and forth, having all these casual conversations, doing their investigation on Aidan Kearney, using Kate Peter as their source. Ms. Peters' November 26, 2023 communication with Mr. Mello conclusively establishes that Mr. Mello outsourced investigative work to her, discussed strategy with her, was aware that she edited Mr. Kearney's content with her own editorial slant and bias, and that he reviewed private links she sent him 2 days before the grand jury proceedings started. So Mr. Mello perhaps committed some misconduct there by outsourcing some work to Kate, strategizing with her, and knowing that she edited those videos, and yet he still put them on evidence. Lieutenant Fanning has testified that Ms. Peter reported things to the MSP and they can't find or document. In December 2023, as part of her plan to coax Ms. Gattani into bringing witness intimidation charges against Mr. Kearney, Ms. Peter told Ms. Gattani that she had blank and that she had spoken to him about blank and blank. Ms. Peter joked that when she spoke to Mello, blank. On December 12, 2023, Ms. Gattani texted Ms. Peter that Mr. Kearney blank. On February 26, 2024, Ms. Peter left Mr. Kearney a crude and harassing voice message gloating about her importance to the Commonwealth's cases against him. And she says, hey, calls him a derogatory term for being gay, and says, it's Kate Peter, you know, crusty panties. You know, every time you get a blocked number, it's not Lindsay or LG or anyone else, it's me. And I just want you to know that when you go back to jail, and I had absolutely everything to do with it because you are a dumb mother effer. I am going to get the best of you. You are a bad person and everyone's going to see it. Have a nice day. By the way, Karen Reed wants nothing to do with you. Go F yourself, bitch. I meant it. Isn't she pleasant? I mean, she's just a ray of sunshine, I'm sure. I'm sure everyone around her is just like, we just love being around her. She's so nice and happy. Not. In March 2024, Ms. Peter boasted under oath in Kearney versus Peter Leominster District Court that Mr. Kearney is angry and upset with me because I have been cooperating with the prosecution and giving them information on him. He can blame me for all of his problems because I am furnishing information. That's a Oh man, don't start. That's a link, so we don't want to watch it. Um, there's just too much to get through. We're already 2.5 hours in and 50 pages in, so we have a little while still to go. But it's moving faster now that we've gotten through most of the exhibits, and a lot of this now is being redacted, so whatever. Tully and Mello's knowledge of distorted evidence prior to the grand jury proceeding. Tully prepared and signed the charging documents filed against Mr. Kearney on October 11th, 2023. We have the charging documents? We do. I got a 70-page document. Yeah, this is 70-page charging documents. I am glad I found this because I used to have it and I lost it, and now I can download it and I'll have it again. Um, so that was his charging documents that they just went to. That link. So Tully wrote them, basically, the 70-page charging documents with all the quotes and things that were taken out of context that they used to charge him. As the special prosecutor in charge of the prosecution, Mr. Mello was familiar with the contents of the charging documents and the evidence against Mr. Kearney at the time of his arrest, which was almost 7 weeks before Mr. Mello elicited testimony from Tully before the grand jury. Mr. Mello billed taxpayers for only 56 hours of work performing during performed during October 2023, even though commencing on October 4th, 2023. And on each and every day, therefore, after including weekends and all legal holidays, I have devoted an absolute minimum of 4 hours each day and frequently 12 or more hours a day. Which meant that before Mr. Mello elicited testimony from DL Tully in the grand jury proceedings, he worked more than 232 hours on Mr. Kearney's case, at least 112 hours in October 23 and at least 120 hours in November of 2023. There's an exhibit to that. Mello's invoice. So then that's based on the numbers that he determined he worked for those hours. So that's his invoice and how many hours he worked on the case. From October 2023 through December 2023, Mr. Mello spent more than 700 hours of time on this matter, his services included, but were not limited to reviewing some 8 months of daily internet posts and blogs associated with this matter, coordinating efforts with investigators, drafting court filings, and making presentations to the grand jury. The charging documents and Mr. Mello's billing records reveal Tully and Mello's familiarity with Mr. Kearney's online videos or episodes and written articles of the Canton cover-up series. Tully accurately cited names of specific episodes, exact timestamps, and exact quotes within them. So in the affidavit that he used or the charging documents, I'm sorry, I guess it's not an affidavit, it's charging documents. So for the charging documents, Tully used the accurate titles and descriptions of the episodes where he was referring to a specific episode. But yet at the grand jury, he somehow had retitled them and forgot all about the fact that they were titled something else in the beginning. For example, DL Tully accurately named the titles of 3 episodes. So 594, Turtleboy returns to Canton. 598, Breaking, Karen Reed, defense file, motion to recuse. 604, Colin Albert drops out of school. Brian Higgins flipping is the engineer. So that was specific episodes blogs that he cites accurately. Tully testified episode 598 entitled Life as Normal is Over and episode 64 entitled I Do Not Want This to Go to Trial. That's what he renamed the clips as. Those are specific words or things that he said throughout, but it leaves out all the context around what he was saying, which gives it like a nefarious type of meaning. Tully repeatedly referenced numerous other unnamed episodes, citing and quoting from them in precise detail. Tully noted that Mr. Kearney's episodes are publicly available for viewing without being a subscriber or follower and have been archived by investigators. So he knows he could find them easily, the names, titles, descriptions, things like that, things that Turtleboy actually titled his episodes, but he didn't bother to use the accurate titles. Thus, it is indisputable that before Mello elicited testimony from Tully during the grand jury proceeding, both men knew the actual titles, length, and content of Mr. Kearney's YouTube episodes. Public availability of Mr. Kearney's content and Tully and Mello's familiarity with it means there was no reason for the Commonwealth to consult with or seek Ms. Peter's input on what evidence should be presented to the grand jury. Right? If they knew that these videos were out there in public, why do they need Peter? Or to clip, edit, and rename Mr. Kearney's episodes and then conceal the actual episodes and their accurate information from the grand jury's consideration. They didn't need to clip episodes, rename them, edit them down, give no context. Ms. Peter's communications with the Commonwealth provide additional proof that Tully and Mello worked hand in hand with her in gathering and editing evidence for use of the grand jury proceedings and intended to deceive the grand jury by intentionally presenting a false and misleading description of Mr. Kearney's episodes. We have a footnote here that says, On January 3rd, 2023, Ms. Peter emailed Mr. Mello and Tully a blank. Mr. Mello forwarded Ms. Peter's email and the link she sent them to Tully and said blank. So who is in charge of the investigation here into Aidan Kearney? Is it the Commonwealth? Is it Jen McCabe saying you've got to do something? Is it Kate Peters saying here's some edited content that makes Aidan Kearney look really bad? You can use this to indict him. Who's leading the charge here? I don't understand. Flawed grand jury presentation. The grand jury proceeding commenced on November 28th, 2023 and continued December 5th, 14th, 19th, and 20th. The main witness against Mr. Kearney was Tully. He testified a total of 11 times over the course of a 5-day proceeding. On December 20th, the grand jury voted to indict Mr. Kearney for witness intimidation, picketing, and conspiracy to commit witness intimidation. Mr. Mello did not seek Mr. Kearney's indictment for illegally wiretapping Mr. Scanlon, yet he brought it up to the grand jury. All of the evidence Mr. Mello presented on November 28th related to the uncharged allegation of Mr. Kearney illegally recording a phone call with Mr. Scanlon. The evidence presented in support of the uncharged allegation of wiretapping consisted of the partial recording Ms. Peter and Tully that Ms. Peter sent Tully and testimony from Scanlon, Tully, and Buchanan, who simply read a hearsay interview report into evidence. And we don't have, do we have it? We do have it. It's a report. Basically from Yuri to Tully. So Yuri is writing this report to Lieutenant Tully about Stephen Scanlon. Fanning and I interviewed Steve during the pre-scheduled time, directed them to the community room. Okay. Stephen stated that he initially reached out to Karen Reed over Facebook Messenger and told her that he was a private investigator and would be willing to put another set of eyes on the investigation, even mentioning that he would do it free of charge. Karen Reed recommended that Stephen contact her attorney, David Yannetti. Stephen stated that he was not sure of the exact date, but he eventually called Yannetti's office and offered the same services, suggesting that O'Keefe might have been beaten up and that he was not sure what happened, but would be willing to work on the case, obviously, only if agreed on by Yannetti that his client. Following their phone conversation, Yannetti asked Stephen to come into the office for further discussion, but he did, which he did back in early 2022. Stephen went on to say that during his visit to Yannetti's office, there was another individual present during their meeting. Stephen identified the male party as Paul Mikowski, who is also a private investigator in Massachusetts, and the two had crossed paths in the past. During the meeting, Stephen was asked if he knew Colin Albert and the ATF agent, both of whom were allegedly in the home during the evening hours when O'Keefe was killed. According to Stephen, this was the first time he had heard of Colin Albert and an ATF agent being possibly involved in the matter, and both had been mentioned by Mikowski and Yannetti. I think that's a lie. I know he told him about Colin. I don't know if he knew about Higgins. Prior to the meeting concluding, Stephen stated that Yannetti handed him a check for $1,200 to $1,500 and asked him to keep his eyes and ears open in the Canton area in regards to the O'Keefe case. Although Stephen took the check, he consulted with his attorney, Tim Flaherty, and returned it back to Yannetti since he was not working on the case and he further felt it would be of conflict of interest. In days and weeks following their meeting, Stephen was in communication with an individual named Jack Hollow. Mr. Hollow, according to Stephen, is a mutual friend of both Stephen and Mikowski and used to work with Brian Albert. Hollow shared information which he had learned from Mikowski. That information being that Yannetti and his team were looking into Colin Albert and the ATF agent since Colin allegedly had beef with O'Keefe. I asked Stephen how come he did not reach out to investigators when he learned this information, to which he stated that everything he had learned was fourth, fifth, or sixth person removed from the source, that he did not think that it was credible or important to reach out to us at that time. At this point, Stephen circled back about an event that he mentioned earlier in our conversation. Stephen had told us that he was at Patty's Irish House in Newton for lunch one of the days following the homicide taking place, and the local news was broadcasting coverage on the case. He sparked up a conversation on the matter with the bartender, who told him that she lives in the neighborhood where O'Keefe was found, and that days following the investigation, she received a call from an unknown party telling her that the police were looking for ring camera footage and not to release it to the authorities. Stephen didn't know the bartender and only provided a physical description of the female and her approximate age being in the 30s. Stephen told us that he also shared this information with Mikowski and Yannetti. So who's telling them don't share it with authorities? She received a call from an unknown party telling her that the police were looking for a ring camera and not to release it to authorities. So whoever called her, an unknown party, called her and said, don't give any video camera to police. They're looking for it. Don't give it over. Is that because they knew the cops were crooked? Or what? Stephen once again reiterated that he told Yannetti and Mikowski that his opinion and theory was that John O'Keefe looked like he could have been beat up, but he had no personal knowledge of what actually happened or who would have been involved in the murder. The name Colin Albert and the ATF agent were mentioned by Yannetti and Mikowski in the meeting and not Stephen. We asked, when was the last time he spoke to Brian Albert since the two used to work together? Stephen told us that he last spoke to Brian in April of this year and that he considers Brian a friend. Stephen told us he knows both Brian and his wife. He also met Chris Albert and Kevin Albert at Brian's house years later. Stephen estimated to be around 1988 to 2001, during the time when Brian was in a bad car crash and Stephen would stop by the house to check in on Brian. So Stephen's a friend of Brian's, but go figure. Everybody's a friend of everybody's in this case. Stephen was asked if he had ever had a phone conversation with Aidan Kearney, whether or not the conversation was recorded by either of them, and if so, was Stephen advised by Kearney about the recording. Stephen stated that in approximately June of 2023, he spoke with Turtleboy following a Saturday Night Live show that Aidan Kearney does on YouTube. The following morning, Sunday after the show, during the episode where Kearney mentioned Stephen by name and his alleged connection to the case, Stephen woke up to a Facebook message from Aidan stating something along the lines of tick tock, you should call me. You shouldn't be scared of Brian Albert. You should be scared of me. Stephen told us he asked Kearney for his number and called him. Prior to talking with Kearney, Stephen told us he stated, before I speak to you any further, is this being recorded? To which Kearney stated, absolutely not. That would be illegal. During their conversation, Stephen told Aidan that he did not know Colin or the ATF agent in question, and he didn't know anything about the case. How do you not know Colin if you're a friend of Brian Alberts? Colin's the nephew that's always around, right? That always is around Uncle Bri Bri. So Aidan told Stephen that he was not talking to the defense, but to close friends of Karen's, and that is where he's getting his information. Stephen told us that he suspected that Yannetti was feeding Aidan his information on the case and the investigation. Stephen recalled sitting on the beach during the summer of 2023 when a friend of his, Irish Ray, Irish Ray, who is also a retired private investigator, contacted Stephen and told him that a recording of Aidan and Stephen's conversation was shared online by Aidan. This was the same conversation that Aidan assured Stephen was not being recorded. Stephen went on saying how upset he was about Aidan recording him without his consent, especially after promising him he would not do such a thing. Stephen had to fight back tears as he told us how upsetting it was to have Aidan drag his daughter into this mess as well. Stephen told us that Aidan told him to call 401 area number that Sunday morning, which is the line that their conversation was held on and at the same time recorded. 401, I don't know. Okay, so we were further told by Stephen that Gretchen Voss of the Boston Magazine publication had reached out to him for comment, something she published, and she never returned her calls. He never returned her calls. Stephen once again told us that his theory was all based on his opinion and the media reports, and that he himself had no personal knowledge of O'Keefe's incident. Additionally, Stephen never spoke to anyone involved in the case, so he would not have any insider information either. At this point, Stephen's attorney, Mr. Flaherty, jumped in and stated that as a result of Aidan's blogs and YouTube live shows, there has been a significant impact on Stephen and his livelihood due to the publicity generated by Aidan, sorry. Stephen is losing work as a result, and it is impacting his reputation in the professional field and on a personal level. Without having anything further to add, we thanked him and sent him on his way. That's written by Yuri, as Kate calls him, just Yuri. Anyways, so that is interesting there, huh? So they just read that into evidence. They didn't actually have Scanlon testify. And of course, as you know, grand juries don't have a defense attorney, so there is no cross examination. So nobody has ever questioned on, I mean, there's no cross examination. So whatever they put in, it's what the prosecution wants in, right? So there's no defense in a grand jury proceeding that are present. The illegal recording played, and by the way, Aidan denies that it was an illegal recording. He says that Kate went and edited the beginning and, edited parts out. And he did say in the beginning, this is being recorded. And he was aware. So the illegal recording played before the grand jury didn't start recording until 1:09 into the call between Mr. Kearney and Mr. Scanlon. Mr. Scanlon claimed that during the non-recorded portion of the audio played before the grand jury, Mr. Kearney told him that he wouldn't record their conversation. Mr. Mello didn't authenticate or otherwise demonstrate the reliability of the partial recording provided to him by Ms. Peter. Mr. Mello didn't instruct the grand jury about the purported relevance of the wiretapping evidence. Mr. Mello didn't instruct the grand jury to disregard any bad act evidence or instruct the grand jury about the wiretapping evidence when considering the charges presented for its deliberation. What Mr. Mello did was instruct Tully to read to the grand jury the text of the wiretapping statute, including its possible punishment of 5 years punishment, which they're not allowed to do. And here's the statute. It's long. I'm not going to read it. But it is about interception of wire and oral communications. So that is on the screen for you if you want to read it. Go slow. You guys can pause and look at it. It's a long one. It's a long one. It's still going. There's a lot of nuances to this, apparently, because it's so long. All right, we'll stop there at offenses. Okay, so that's a long document. That's actually 13 pages. We only got a few in. All right, so at the conclusion of the November 28th, 2023 session, Mr. Mello informed the grand jury that this case involved a violation of Statute 27299, after which he summarized the definition of the wiretapping statute, which meant the grand jury heard it twice that day. You're not supposed to do that. You're not supposed to define, I guess, the wiretapping twice, or if you do, it's prejudicial in some way. So after November 28th, 2023, Mr. Mello never referred to the wiretapping allegation again in the grand jury proceedings. So that wiretapping that he was, that they were accusing him of, they never even referred to it later in an allegation. On September 11th, 2025, I was informed by Mr. Cosgrove that Mr. Mello decided not to proceed with a request for the grand jury to indict Mr. Kearney for allegedly wiretapping Mr. Scanlon. On information and belief, if Mr. Mello decided not to seek a wiretapping indictment after November 28th, 2023, then he realized that the audio recording Ms. Peter gave Tully wasn't reliable evidence. There were no other logical reasons for Mr. Mello to call 3 witnesses, introduce the recording, and introduce a hearsay report in support of a wiretapping indictment and not seek an indictment unless he realized that the evidence wasn't reliable or he offered the evidence exclusively for the purpose of prejudicing Mr. Kearney before the grand jury deliberated on the submitted charges. As the legal advisor to the grand jury, Mr. Mello knew or should have known that he should have decided to not proceed with seeking an indictment. Uh-oh, doggy time. Dogs are playing. Hold on. Sorry about that. They are now playing outside. Like, get out of here. I don't want to hear you barking. All right, so as a legal advisor to the grand jury, Mr. Mello knew or should have known that he should have decided not to proceed with seeking an indictment for a serious crime before he severely prejudiced Mr. Kearney by calling witnesses, playing a recording, and twice instructing the grand jury on the elements of and once on the punishment associated with the uncharged wiretapping allegation. As the legal advisor to the grand jury, Mr. Mello knew or should have known that if he decided not to seek Mr. Kearney's indictment for wiretapping after he presented voluminous evidence in support of that uncharged crime, at a minimum, he was obligated to instruct the grand jury that A, it must disregard all evidence in support of that uncharged bad act, B, it may not consider that evidence as proof of Mr. Kearney's bad character, and C, it must disregard all legal instructions provided about the charge, including any possible prison sentence, and D, it may not consider any of the evidence presented on November 28th in considering the submitted charges. Mr. Mello didn't provide any of these instructions. Without more, Mr. Mello's presentation of irrelevant and prejudicial evidence of an uncharged bad act that bore no relationship to the charges before the grand jury impaired the integrity of the grand jury proceeding. And that's according to Commonwealth versus Brown, where intentional admission of prior bad acts without curative instruction may impair the integrity of a grand jury proceeding. Most of the evidence Mr. Mello offered in support of charges that he actually presented for the grand jury's consideration consisted of what he and Tully knew were cherry-picked out of context snippets from Mr. Kearney's online content. The critical issue for the grand jury's determination regarding the witness intimidation charges was Mr. Kearney's intent. Mr. Mello improperly expressed his unsworn opinion that Mr. Kearney's intended to intimidate witnesses. Mr. Kearney improperly, I'm sorry, I said Kearney. Mr. Mello improperly elicited Tully's opinion that Mr. Kearney's intended to intimidate witnesses. Mr. Mello improperly elicited from Ms. McCabe, Matthew McCabe, and Ms. Nagel their opinions of Mr. Kearney's intent. Mr. Mello and Tully deliberately misled the grand jury by giving it the false impression that Mr. Kearney named his episodes in a manner suggestive of his intent to intimidate witnesses. 14 times during the grand jury proceeding, Tully improperly testified that the grand jury exhibits were maintained in a folder titled Intent. And we can't see that because it's grand jury stuff. We don't get to see it. Mr. Mello and Tully concealed from the grand jury that Tully, not Kearney, created and named the intent folder, and Tully, not Kearney, renamed the clips Tully edited from Mr. Kearney's actual episodes. Again, back to that affidavit from Courtney Healy. So a lot of these are just reiterated. I think we've been through the majority of all the the attachments and exhibits, but they're reused a bit sometimes. So Mr. Mello neither instructed the grand jury to disregard Tully's repeated reference to retrieving videos from the intent folder names, nor told the grand jury that it was the exclusive fact finder on the question of Mr. Kearney's intent. So it didn't tell them, hey, you guys get to determine what his intent was, not these witnesses. After being peppered with improper questions that Mr. Kearney intended to intimidate witnesses, the grand jury was left to speculate and likely incorrectly believed that Mr. Kearney, not Tully, created the intent folder. If the grand jury knew that the intent folder, the episode names described to it, and the edited clips that became the grand jury exhibits all were created by Tully instead of Kearney, the probable impact of such evidence would have been substantially less. Either way, by repeatedly encouraging Tully to testify that the edited videos occurred to prove Mr. Kearney's intent were maintained in a folder named intent, Mr. Mello intentionally and improperly bolstered the distorted evidence because Tully's testimony was tantamount to additional expressions of Mr. Mello and Tully's opinion that Mr. Kearney's intent was to intimidate the witnesses. Mr. Mello and Tully further deceived the grand jury by playing edits of Kearney's lengthy episodes and then depriving the grand jury from the complete and accurate context contained in this actual episode. The sleight of hand dramatically misrepresented the context of the episodes in their names and deprived the grand jury of the right to the complete statements made by Kearney. Let's see Commonwealth versus Mayfield. Failure to disclose known information may impair a grand jury proceeding. It's also according to Odell. Prosecution's introduction of inculpatory portion of statement distorted by the intentional failure to include exculpatory portion of statement impaired grand jury proceedings and required dismissal of indictment. The cumulative impact of Mr. Mello's concealment of the actual titles, length, and full context of Mr. Kearney's episodes deliberately kept the grand jury ignorant of the truth. Mr. Kearney's mostly hours-long episodes were dedicated to subjects far different than the edits and names Ms. Peter provided to Mello and Tully, and included elements of comedy and satire. Footnote 19. Mr. Mello and Tully's scheme to mislead the grand jury with evidence that Mr. Kearney's episodes' names were indicative of his criminal intent even misled this court and Mr. Cosgrove. In sustaining a number of the witness intimidation counts, the court, in its May 19, 2025 decision, understandably referenced the episodes by the false names provided by Mr. Mello and Tully in a manner suggesting it believed the names were created by Kearney and were relevant to its decision. Do we have the copy of this? Judge Doolin's decision on Kearney's motion to dismiss. Okay, we do. It's a 37-page document, so I don't know where it's located, so it's in there somewhere. In a July 2019, why do I keep doing that? I keep saying the wrong freaking number. In a July 29, 2025 filing, Mr. Cosgrove, who apparently unaware that Mello and Tully distorted the evidence in reference to Kearney's intent, cited the aptly titled episode 616, Trying to Destroy Colin's Life. When in fact, that episode is named Karen Reed Case, Commonwealth Tells More Lies About John O'Keefe's GPS Data. Big difference. Big difference there between Trying to Destroy Colin's Life and Commonwealth Tells More Lies About John O'Keefe's GPS Data. Totally different intentions behind those titles. As detailed in the following chart, the Commonwealth engaged in pervasive misconduct by repeatedly misleading the grand jury about Mr. Kearney's episodes. So, McCabe Residence, this is the title testified to by Tully. McCabe Residence and Turtleboy returns to Canton, door knocking, grilling public officials. Cops called on me. Tully labels this one confronting McCabe's outside Norfolk Superior. McCabe's want to kill me. Sean McCabe isn't happy Karen Reed speaks out. Next one, needs to go to McCabe's soccer game again. When this one is Karen Reed case, where's Michael Proctor? This one's just titled Jen McCabe. This one is actually titled Karen Reed case, breaking down the fraudulent charging docs on Turtleboy. Different. Very different. All of these very different things that you can imagine. Next one, number 5, can kick Colin Albert's ass, when it's actually titled Kendra Lara crash, Sean interview, Paul O'Keefe and Carl Dougal defend Canton murderers. Next one, call to Colin Albert, or actually what it's titled, Amiri King wants to fight Turtleboy, Canton updates, Auntie Bev, Canoni out of control. Very different, aren't they? Next, trying to destroy Collins Albert's life, Commonwealth tells more lies about GPS data of John. Colin Albert is the next one, and really it's titled Karen Reed case, breaking down the fraudulent charging docs. Call to Julie Albert is actually called More Michael Proctor Lies and Making Calls. Life as Normal is Over. That's what Tully calls it, but it's actually called Breaking Karen Reed Defense Files Motion to Recuse Judge Canoni and Oppose a Gag Order. Now, if you use the actual titles of Turtleboy's episodes, the jury might maybe get an inclination that Turtleboy is fighting the Commonwealth, right? Because of his titles. So they had to retitle them. Because otherwise, they would get the impression that he's actually fighting the good fight. He's on the good side of corruption. He's fighting the fight to reveal and expose corruption. Very different. Impromptu Live. Alberts should be afraid, which is actually called Impromptu Live. Karen Reed's parents go on Boston 25 News and new bombshell information. So Alberts should be afraid, or bombshell information. Same thing, right? I guess in Tully's eyes. Kearney outside D&E 2. This is looking for Jim Ferris, Chris Albert, and the Galvins in Canton. Call to Elizabeth Proctor, actually titled Elizabeth Proctor, Dumbest Wife Ever, Brian Albert Opposition Motion. Next one is Not My Last Trip to Canton. Turtleboy returns to Canton, door knocking, grilling public officials. Cops called on me. Not My Last Trip to Canton. Turtleboy returns to Canton. Same thing. Living Like Rats is actually Karen Reed case. Attorney Bob Mata discusses Friday's hearing confrontation in Canton. This one from Tully, not leaving second generation out of it. Same thing, the Bob Mata one. Response to D.A. Morrissey's statement, Impromptu Live, Drunken Lardo, Michael Morrissey declares war on turtle riders. Pretty much. Life as Normal is over. Didn't we do this one already? Yeah, that's the breaking Karen Reed, files to recuse Judge Canoni. Time to hit the gas. Same motion. Enjoying watching witnesses squirm. That is pre-vacation show, Fupasaurus, Jill Daniels, Carl Dougal, Tail Light Mystery, and Liz Proctor. I do not want this to go to trial. Colin Albert drops out of school. Brian Higgins flipping, and is the end near? What's the yes? Oh, so all of these down here, Brian Tully told the grand jury that these were in the intent folder specifically. Trying to destroy Colin's life, the GPS data of John, no right to live peacefully. It's actually titled Karen Reed case, Detective Buchanan intimidates witnesses, Chris Albert seeks protection order. 25, I've got pictures of you, that's breaking, Karen Reed defense files motion to recuse Judge Canoni and oppose gag order. 624, Karen Reed case. Affidavit shows bathroom video was PC to take journalists' phones. Impromptu live. Alberts should be afraid. These are repeats. Rolling rally. Don't feel bad for O'Keefe's. Don't feel bad for the O'Keefe's. It's called. But it's really called Canton, the Justice for Karen Reed and John O'Keefe Rolling Rally. The next one, I'm not fucking around, and it's actually the Turtleboy Returns to Canton one. The above chart and Mr. Mello's conduct on December 20th, 2023, immediately before he sought Mr. Kearney's indictment, best demonstrates how he repeatedly impaired the integrity of the grand jury proceeding and prejudiced Mr. Kearney by misleading the grand jury about the evidence of Mr. Kearney's intent. Prior to December 20th, 2023, Mr. Mello already had spent an extraordinary amount of time and effort introducing inflammatory and irrelevant evidence and instructions related to an uncharged bad act. Prior to December 20th, 2023, Tully already had falsely and improperly testified about the location, names, length, and content of at least 17 edits from Mr. Kearney's episodes. Prior to December 20th, Mr. Mello already had bolstered his improper presentation of evidence by eliciting Tully's affirmative statement that, quote, these incidents, videos previously played, were all attempts to intimidate these witnesses. How do you know that, Brian Tully? On December 20th, 2023, Mr. Mello bolstered his previous misconduct with his unsworn opinion and Tully's sworn opinion by eliciting Tully's agreement with him that edited exhibits depicted Aidan Kearney making some comments about his intentions with respect to his activities. So they characterized the statements he made as his intentions. That is, I'm sure, not allowed. Immediately following this improper marshaling and bolstering of the edited evidence, Mr. Mello instructed Tully to play the videos which he just told the grand jury he and Tully believed proved Kearney's intent. Tully proceeded to play a series of videos which he again improperly testified came from the intent folder. As they did 17 times previously over the past 3 sessions, Mr. Mello and Tully intentionally misrepresented the names of Mr. Kearney's episodes to make them sound consistent with what they told the grand jury was Mr. Kearney's criminal intent, and then DL Tully played out of context, cherry-picked snippets while Mr. Mello deprived the grand jury of the full context and accurate names of Mr. Kearney's episodes. Tully matter-of-factly falsely swore that among Mr. Kearney's episodes from the intent folder were episodes he prejudicially named, but the grand jury was led to believe Mr. Kearney named, such as enjoying watching witnesses squirm, trying to destroy Colin's life, and no right to live peacefully. As if Mr. Mello and Tully's conduct already wasn't bad enough, they exacerbated the prejudice to Mr. Kearney by further bolstering the evidence and their improper opinions of it by replaying edited videos and repeating their false names for videos, even though they already had been presented to the grand jury. Specifically, on December 20th, 2023, Mr. Mello replayed the following misnamed and misleading episodes: trying to destroy Colin's life, life as normal is over, impromptu live, Alberts should be afraid. Of course, they play the worst named ones, right? No members of the O'Keefe family testified before the grand jury. Mr. Mello didn't seek Mr. Kearney's indictment for the alleged witness intimidation of any members of Mr. O'Keefe's family. Tully testified that the final video played in the grand jury presentation came from the intent folder and was entitled Rolling Rally, Don't Feel Bad for the O'Keefes. Tully explained that the final video's name referred to the parents and family of John O'Keefe. The length of the actual video made by Kearney was 2 hours, 8 minutes, and 13 seconds. The actual title of the video made by Kearney was Canton, the Justice for Karen Reed and John O'Keefe Rolling Rally. As the title and content of the actual video made by Kearney demonstrates, the grand jury was misled and deprived of evidence that, in addition to Ms. Reed, Mr. Kearney stated he was seeking justice for Mr. O'Keefe. They kind of left that part out, that he was also seeking justice for Mr. O'Keefe. The small clip of the misnamed video was irrelevant to the charges before the grand jury because it wasn't offered in support of allegations that Mr. Kearney had intimidated anyone from Mr. O'Keefe's family. Mr. Mr. Kearney's brief discussion of the O'Keefes centers on his frustration that they have been misled about who was responsible for Mr. O'Keefe's death and the impact their belief had on Ms. Reed. The final clip constituted another example of Mr. Mello improperly introducing uncharged bad acts evidence to prejudice Mr. Kearney and to appeal to the emotions of the grand jury. Mr. Mello didn't instruct the grand jury on the purported relevance of the final edited exhibit or caution the grand jury to limit its deliberations to relevant evidence and make sure the sympathy for Mr. O'Keefe or his family didn't influence their evaluation of the evidence. At the conclusion of Tully's December 20th testimony, just as he did immediately before Tully testified, Mr. Mello informed the grand jury that he had presented it with sufficient proof of Mr. Kearney's intent to intimidate witnesses. Now, to prove intent, the Commonwealth has to prove the purpose or objective of any behavior of the defendant, which would be Mr. Kearney. Obviously, it is impossible to look directly into his mind, but we believe that evidence has been presented to you that would allow you to make that determination. We can't look inside of his mind. Mr. Mello asked Tully if the videos depict Mr. Kearney making comments about his intentions. Mr. Mello asked Tully if it's your contention that incidents in the video clips were all attempts to intimidate these witnesses, to which Detective Tully replied yes. Did I miss a footnote somewhere? I don't see it. Oh, there it is. Okay, so throughout the grand jury proceeding, Mr. Mello engaged in other improper conduct that combined with the above cited examples had the cumulative impact of impairing the integrity of the grand jury proceeding. Before we get to the includings, let's read this footnote 20 that says Ms. McCabe testified that she received threatening Facebook messages from Mr. Kearney and others. She said that she provided them to the Commonwealth. She described messages which physically threatened her and others which included pictures of her daughter and something redacted. None of these messages were presented to the grand jury, and to this day, they haven't been disclosed to the defense. So everything that she stated, we don't have receipts for. All right, so now to the including. So cumulative impact on impairing the integrity of the grand jury, including allowing grand jurors with a strong opinion about Mr. Kearney to decide for themselves whether they felt comfortable and telling them they were welcome to stay instead of instructing them to recuse themselves from this matter. Whoa. So they told people if you know Kearney, that's okay? A grand juror indicated that he or she knew Ms. Nagel. Mr. Mello, who already improperly opined that Ms. Nagel was a victim of intimidation, tried to excuse the grand juror for Ms. Nagel's testimony only. Remarkably, the grand juror had to instruct Mr. Mello that it is not appropriate for him or her to vote on any counts and that he or she needs to be excused. He was just going to let him continue. Okay. Informing the grand jury of sentencing possibilities for charged and uncharged crimes, repeatedly asking witnesses their opinion on Mr. Kearney's intent and other witnesses knew or believed, referring to Mr. Kearney's followers as his minions, that's nice, expressing confidence that the grand jury will find the witness to be the victim of intimidation. The defense's specific demand for evidence. On February 23, 2024, the defense demanded from Mr. Mello, among other things, statements made by possible witnesses to Tully, all statements between or among any civilian witnesses, police, or prosecutors, and material subject to disclosure under Rule 14, including reports, statements, and videos. See if we have that. That is Aidan asking for all of these things that are listed. So information relative to officers involved, statements, text, emails, any such documents, anything. Give us the discovery. That's what they're asking for here. Lots of it. Quarry records, police statements, and things of that nature. Calls to the police. They're asking for all of that. On March 19th, 2024, the defense informed the Commonwealth that Mello's response to the demand was inadequate and that he had failed to disclose all automatic discovery. So the things that he's supposed to be turning into discovery, he's not. He's not turning over to the defense. This is a motion for overdue automatic discovery. So even just discovery he's supposed to be turning over, he has not. This is talking about the specific requests, and they're not getting it. So they're putting it all in writing, making a record that they're not complying. Mr. Mello didn't comply with the May 8th, 2024 deadline to disclose all discovery to the defense. And this is footnote 22, which says Mr. Mello's failure to comply with the court-ordered deadline wasn't the first time he has neglected important legal matters. He has been disciplined for neglecting at least 3 matters. This is a public reprimand of Ken Mello. Interesting. Let me take a peek here. So this is a summary. I don't want to read through all of it, and I'm not sure if I understand it all. So basically, he didn't advise his client of things. He failed to allege damages. Ultimately contacted the court on her own. The client contacted the court on her own and learned of the dismissal for the first time. She didn't even realize that her charges had been dismissed. He didn't even communicate that to her, this one lady. In a second case, criminal matter, client was convicted and sentenced. The respondent, trying to see what he did. Okay, he did not return the client's file in order to enable him to pursue an appeal. Well, that's a problem. Or retain other counsel. The respondent also failed to file a notice of appeal for the client. So he didn't appeal for the client. He didn't hand over the case file for the client. Nothing. Client later demanded the return of his files, but the respondent did not comply until bar counsel opened an investigation into the issue. So Ken Mello has some issues here. Respondent's misconduct in the above cases was aggravated by the fact that he received an admonition in 2006 for similar misconduct. Specifically, he failed to prosecute a client's case, resulting in its dismissal, and failed to communicate that with the client. On May 6, 2016, the parties submitted a stipulation to the board in which the respondent admitted the truth of the above facts and stipulated to the above rule violations. So he agreed, like, yes, I did this. The parties recommended that the respondent receive a public reprimand. The board accepted the parties' recommendation. So this is his public reprimand that that people know that he sucks. So that was that. All right. So in 2016, he was publicly reprimanded for performing very little work of substance and failure to communicate with his client. He was further reprimanded in a second matter due to his professional incompetence in failing to file paperwork for which he was legally required to do in connection with the criminal client's appeal. In 2006, he was admonished for similar misconduct for failing to prosecute a client's case resulting in its dismissal and for failing to communicate with his client. Morrissey must have known or should have known about Mello's documented failures to comply with his professional obligations before he engaged him to prosecute Kearney at the taxpayer's expense. On information belief, around the time of the court issued the discovery deadline, Mr. Cosgrove joined the prosecution team on May 8, 2024. Mr. Cosgrove, to his credit, acknowledged that Mr. Mello impeded progress on discovery. So Mr. Cosgrove admitted Mello was, impeding, to say it nicely. He was the holdup. He was making discovery wait. So he provided some discovery to the defense, although none of it related to Ms. Peters' interactions with Mello or Tully. This is delivered by hand. This is a list of things that Cosgrove then handed over once he got on the case. So Gattani stuff, grand jury stuff. They didn't even have grand jury minutes. Holden arrest report. Oh, that was Aidan's arrest report when for Lindsay Gattani. So this has nothing to do with any Kate Peter stuff. So yeah, okay. On July 10th, 2024, in response to the defense's March 19th, 2024 demand, Mr. Cosgrove stated that the Commonwealth would provide all evidence required under Rule 14 and recognized its obligation to provide exculpatory evidence. This is his response, I think, to Aidan, saying we'll give you that or something. Statements made. I don't know what this is. Commonwealth's response to the defendant's motion for specific discovery. So yeah, he's responding to each and every one of the things that they were asking for. Beginning in the fall of 2024, the defense made a series of specific demands for favorable and discoverable evidence pursuant to Brady and Giglio and Rule 14. Many of these specific demands sought evidence related to Ms. Peters' relationship with the Commonwealth. Until July 2025, the Commonwealth didn't disclose any evidence responsive to the defense demands for evidence related to Ms. Peters' relationship with the Commonwealth, including her involvement in the investigations against Mr. Kearney. The fact that she was basically investigating him for the cops. Although the Commonwealth has provided some materials related to Ms. Peter, their production to date has been woefully inadequate. The Commonwealth has represented that certain evidence provided by Ms. Peter to Mr. Mello and Tully in 2023 is no longer in their possession, custody, and control, and has since been deleted on information belief by Ms. Peter. Although the undisclosed evidence indisputably was in their possession, custody, and control, the Commonwealth regrettably has taken that position that they are not obligated to disclose this evidence because it is no longer in its possession, custody, or control. The court should soundly reject this weak justification for the Commonwealth's failure to preserve and provide exculpatory and/or discoverable evidence to the defense. On September 12, 2024, I sent a specific demand to Messrs. Cosgrove and Mello, in which the defense sought from the Commonwealth any information in their possession, custody, or control that tended to impair the credibility of any possible witnesses against Mr. Kearney, and all promises, rewards, or inducements made to any possible witnesses against Mr. Kearney. We have another exhibit here. It's not clickable. Okay. The demand included information related to Ms. Peter and Tully. In this demand, I detailed Ms. Peters' prominent role in a conspiracy created in December 2023, the purpose of which was to lure Mr. Kearney into being charged with witness intimidation of Ms. Gattani after Tully served her with a grand jury summons issued by Mr. Mello. Mr. Mello had direct involvement in his scheme. Mr. Mello's direct involvement in this scheme was so great. Sorry. Mr. Mello's direct involvement in this scheme was so great that it resulted in the court disqualifying him from the prosecution of the 2024 indictments, in which Ms. Gattani was an alleged victim. So let us take a look at that. Footnote 23. Ms. Gattani has since filed lawsuits against Mr. Cosgrove and Tully for what she alleges are their improper actions in the 2024 indictments, including intentionally causing her emotional harm. She also sent a demand letter to DA Morrissey in which she strongly implied her intent to sue the DA for at least $50,000 unless she is financially compensated soon. In addition to further sabotaging her own credibility, Ms. Katani virtually unprecedented scorched earth blame everyone legal maneuvers have created an irre, uh, irreconcilable conflict with that requires Mr. Cosgrove and Tully to immediately disqualify, because she sent the letter to Cosgrove and Tully, so they need to get off the case. Yeah, so they should be immediately disqualified from both the 2023 and 2024 indictments. I informed the DA that an extraction report from Ms. Katani's cellular phone provided to the defense appeared to have scrubbed communications from Ms. Peter, Mr. Mello, Tully after Katani and Ms. Peter discussed something. The Commonwealth didn't respond to this specific demand for evidence. On October 8th, 2024, I sent Messrs. Cosgrove and Mello another specific demand. This detailed 15-page demand was entirely devoted to production of exculpatory and discoverable evidence related to Ms. Peter, including all evidence and information in whatever form Ms. Peter furnished to the Commonwealth and or MSP involving the investigation or prosecution of Mr. Kearney, any records of Ms. Peters' communications with the Commonwealth and MSP between October 1st, 2023 and the present, and any documentation or memorialization of statements made by Ms. Peter to the Commonwealth or MSP regarding Mr. Kearney in any form, including but not limited to written reports, notes, email, text messages, audio, and video recordings. Commonwealth didn't respond to this specific demand for evidence. They're asking for very specific things, and the Commonwealth is just ignoring them. And this has been a repeated pattern over and over again. And he has to lay out, like, look, we've been asking for this stuff multiple times over the years, and we're not getting it. And we're asking for it specifically. They're just ignoring us. On October 17th, 2024, I sent Mr. Cosgrove another specific demand for exculpatory and discoverable evidence. In this demand, much of which related to our recent discovery that DA Morrissey improperly conducted official public business from his personal email account, I again alerted the Commonwealth to Ms. Peters' direct involvement in this case. Yet again, the Commonwealth didn't respond to this specific demand for evidence. On December 16th, 2024, Mr. Mello forwarded some communications between himself and Ms. Peter to Mr. Cosgrove. Do we have these? No, none of those work. All right. Notwithstanding our prior demands, Mr. Cosgrove didn't supply the evidence to the defense until July 7th, 2025, almost 7 months after he received it. As explained, the untimely disclosed communications between and among Ms. Peter, Mr. Mello, and Tully is critical to the instant motions, and if it has been disclosed promptly, would have been included in support of the defense's first motion to dismiss the indictment. So remember, I said that they had a motion to dismiss their first one, that some got dismissed and the others are still, on the table. That one, they didn't have all of this information before. Otherwise, they would have included it. This has all come out since their first motion to dismiss. On March 29th, 2025, I sent Mr. Cosgrove another specific demand for evidence related to the Commonwealth's relationship with Ms. Peter. Once again, I demanded any evidence, including but not limited to Ms. Peter's involvement in Mr. Kearney's case, such as evidence of interactions and communications, including their substance, between and among Ms. Peter and the Kearney and Reed prosecution teams, which included Mello, Tully, Buchanan, Proctor, Fanning, and others. I informed Mr. Cosgrove that it had been more than 5 months since our first specific demand and that the Commonwealth still hasn't disclosed any information or materials in response to our demands. I again provided detailed facts which established there was no doubt that the Commonwealth had in its possession, custody, or control undisclosed materials related to its relationship with Miss Peter. On July 7th, 2025, the Commonwealth disclosed some evidence related to Ms. Peter, including the messages forwarded by Mr. Mello to Mr. Cosgrove on December 16th, 2024, and a few emails Ms. Peter sent DL Tully without his responses. The Commonwealth representative turned over 4,727 pages of Detective Tully's emails. In fact, more than 4,000 of those pages were blank. Remember that? On July 12th, 2025, I wrote Mr. Cosgrove once again making a specific demand for all evidence related to Miss Peter. Since July 12th, 2025, the Commonwealth has provided some additional Peter evidence, including a file containing the previously blank Tully emails, while alleging that some of the evidence is no longer in their possession, custody, or control. On August 13th, 2025, Mr. Cosgrove represented to the court that Tully had a practice of not clicking on the solicited links. I bet this is going to be a link to YouTube. Yeah, it's the hearing, a link to their hearing where he said that. So he said that Mr. Cosgrove got up and said to the judge, Tully doesn't have a practice of opening or clicking on unsolicited links. Sure. Email to him, but instead might go himself and look for it online. Mr. Cosgrove further stated that DL Tully did not review any materials sent to him by Ms. Peter which were introduced before the grand jury. For example, Mr. Kearney's YouTube presentations that were introduced to the grand jury, all of those things that Tully found himself online. He may have been pointed to them by Ms. Peter, he may have been pointed to them by multiple sources, but he never clicked on whatever it was that was sent, so they were never accessed in effect by the Commonwealth. Who believes that? Raise your hand if you believe Commonwealth didn't click on those links. No one? Okay. That's what I thought. If the links are now dead, we've never seen them. The links are presumably dead because whoever sent them took them off the internet. That would be you, Kate Peter. If Tully had clicked on the link, it would have taken him somewhere, probably would, but he didn't. I think Cosgrove just flat out lied in front of the judge. There is a strong reason to doubt the truthfulness of Tully's claim to Cosgrove. Ms. Peter forwarded recordings to MSP in a private link. Tully swore that she provided the audio recording to him in a private link. Of course, we can't click on that. After Tully, blank. Sergeant Buchanan informed Tully and others that he already provided blank to ADA Lolly. Even if Tully didn't personally review any links sent to him by Ms. Peter, Mr. Cosgrove's representation that the Commonwealth in effect never accessed the links provided to them by Ms. Peter ignores indisputable proof that Mr. Mello accessed the materials Ms. Peter provided to him. I can't click on these exhibits. Once the links were sent by Ms. Peter and received by any agents of the Commonwealth in 2023, that evidence was in the Commonwealth's possession, custody, and control, and it was obligated to disclose the evidence to the defense under Brady, Giglio, and the pre-existing Rule 14 requiring disclosure of any written or recorded statements and the substance of any oral statements made by the defendant in prosecution's possession, custody, or control, persons under their direction or control, or persons who have participated in investigating, that'd be you, Kate Peter, or evaluation of the case, or have reported to the prosecution. Still you, Kate Peter. That's all you. No later than May 8th, 2024, when the court ordered all automatic discovery to be sent to the defense. Mr. Mello is a material defense witness. Oh, we've seen this already. This is Judge Doolin's ruling to disqualify. The court already has disqualified Mr. Mello from Kearney's 2024 indictment because he made himself a material defense witness. Mr. Mello's interactions and communication with Tully and Ms. Peter and his conduct before the grand jury has made him an essential defense witness. Mr. Mello's direct advocacy in seeking to have criminal charges lodged against other individuals while acting as both an advocate for witness Chris Albert and in his official capacity as Mr. Kearney's prosecutor creates an actual conflict of interest, makes him a material witness, and compels his disqualification. I'm going to sit down. He's bored, I think, trying to decide what to do. So he's just walking all over the place. Yeah, eat that. He just lost a tooth today. He just lost a big canine tooth. All right. So on November 5th, 2023, weeks after Mr. Kearney had been arrested, Mr. Mello called the police on behalf of Chris Albert, who already was a named witness against Mr. Kearney, to report that people were picketing Mr. Albert across the street from his Canton pizza shop. In his call to police, Mr. Mello initially identified himself as a prosecutor with the Norfolk DA's office. He immediately asked to speak to the supervising sergeant. Mr. Mello reported a protest occurring near Mr. Albert's pizza shop and requested that a police car respond to make sure they are not intimidating. After Mr. Mello was asked to confirm his identity, he properly disclosed that he was not a Norfolk County prosecutor, but the special prosecutor on Aidan Kearney. Not surprisingly, after hanging up with Mr. Mello, the officer who took the call properly noted to a fellow officer, "Well, they can protest." An officer called Mr. Mello back and told him that the incident amounted to nothing more than 4 people holding signs across the street from D&E Pizza who weren't impeding traffic. The officer noted, "It seemed kind of mellow. It's a small group now." Okay, dog, can you stop messing with my mouse? And I want to highlight that. Okay, stop. Yeah, that's not for playing. He likes to play with my mic. I don't know what. He's bored. Okay, now he's hold on. I think he dropped his bone. Sorry about that. All right. Undeterred from his advocacy for Mr. Albert, Mr. Mello asked the sergeant to look at Section 268.13a. After reviewing the witness intimidation statute, the sergeant asked Mr. Mello what he was thinking of doing. Mr. Mello urged the Canton police to either charge or disperse them because they met every single requirement of the statute. According to Mr. Mello, that those protesters were certainly there to influence Mr. Albert or whatever else that statute states. So he doesn't even know what the statute states. He's like, they were there to influence him or whatever the statute means. They weren't there for any other reason. Mr. Mello's conduct and his credibility will be key issues at trial, and it would therefore be improper for him to advocate for the Commonwealth as an unsworn witness. Mr. Mello must be disqualified pursuant to the witness advocate rule as codified by Rule 3.7, which mandates that a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. A lawyer must be disqualified if representation would taint the legal system or the trial. The need for an evidentiary hearing. We're getting to the end, guys. This went way longer than I had hoped. Didn't want to spend this amount of time reading this, but it's good that we're reading and looking at the filings that go with it, all the exhibits. The defense has provided substantial evidence in support of our motions that, at a minimum, raise substantial material questions of fact that the court must resolve before determining the defense motions. With respect to the motion to dismiss the indictments due to the prosecution's impairment of the integrity of the grand jury proceeding, the defense, at a minimum, has raised material questions of fact regarding why the Commonwealth presented the grand jury with uncharged evidence related to wiretapping of Mr. Scanlon and whether they did so for the purpose of seeking an indictment on the charged offenses, whether Tully or someone else created and or provided the evidence used before the grand jury, why he created or edited videos, why he created the intent folder, why he changed the names of Mr. Kearney's episodes, and whether Mr. Mello was aware of any of this and whether they discussed it in advance of the grand jury presentation. Why Mr. Mello didn't enter Mr. Kearney's complete episodes into evidence, Why, if Mr. Mello knew the actual names, length, and content of Kearney's episodes, did Mr. Mello elicit testimony from Tully in the manner he did? What evidence did Tully provide to the Commonwealth? To whom did she provide it? What evidence did Miss Peter provide to the Commonwealth? To whom did she provide it? Who reviewed it? And did anyone vet its authenticity or reliability? And if so, when? What is the complete substance and nature of communications between Tully, Mello, and Peter regarding Tully's claim that he didn't review any links that she sent him? Did Mr. Mello, Tully, any other agents of the Commonwealth review, preserve, disclose, or delete evidence provided by Ms. Peter? Did Ms. Peter delete or destroy evidence? And whether any or all of the answers to the above material facts establishes that the Commonwealth misled the grand jury by intentionally or recklessly presenting false or misleading evidence, or in any other manner that impaired the integrity of the grand jury proceeding for the purpose of securing Mr. Kearney's indictment. With respect to the motion to dismiss the indictments for the prosecution's failure to provide exculpatory and or discoverable evidence, the defense, at a minimum, has raised material questions of fact regarding what efforts, if any, the Commonwealth made to promptly respond to the numerous specific defense demands, including inquiries made with respect to Ms. Peters and others. Why did it take years for the Commonwealth to disclose exculpatory evidence and automatic discovery? An inventory of all evidence Ms. Peter provided to the Commonwealth, including to whom she sent it, and what evidence was preserved, disclosed, lost, or edited. Whether evidence provided by Ms. Peter was edited or tampered with by her or anyone else, whether any deletions, non-disclosures, and or untimely disclosure of evidence was intentional, why her communications between and among Mr. Mello, Tully, and Ms. Peter from September 23 through early 2024 disclosed by Mr. Mello months after defense specific demands, and why did Mr. Mello fail to disclose them for another 7 months? So Mello held them, and then Cosgrove held them again for another 7 months. Why was the Commonwealth failed to disclose alleged written communications that Ms. McCabe has sworn she provided to the Commonwealth? With respect to the defense motion to disqualify Mr. Mello, the defense, at a minimum, has raised material questions of fact regarding Mr. Mello's knowledge of Ms. Peters' dubious credibility, including her bias against Mr. Kearney, her motive to falsely accuse him, and her history of forging evidence against Mr. Kearney. Mr. Mello's communications with Ms. Peter regarding her input and production of evidence, including his knowledge and whether Tully reviewed evidence provided by Ms. Peter. Mr. Mello's knowledge about how he and Tully prepped for the grand jury, whether they discussed how Tully was going to describe Mr. Kearney's episodes, and whether Mr. Mello and Tully intentionally misled the grand jury. Mr. Mello's knowledge of whether Tully, Ms. Peter, or anyone else edited clips and changed the names of Mr. Kearney's episodes prior to the grand jury presentation. Wherefore, just like climbs my lap. Wherefore, as alleged herein and detailed in the accompanying memorandum of law, the defense requests dismissal of the indictments and the disqualification of Mr. Mello, or in the alternative, an evidentiary hearing on our motions and any other proper relief deemed just and proper by the court. Signed, Mr. Bederow. This was submitted September 17th, 2025. So there you have it. The entire motion to dismiss for Aidan Kearney. We went almost 4 hours talking with going through the exhibits. Crazy, right? If even like a fraction of what they are claiming is true, they have still a good case for dismissal, right? But all of it combined, all of it together, I think really warrants at least an evidentiary hearing. And hopefully they get it. That will be some good television to watch once it, if they air it, which they should, I would think. And I would love Turtleboy has already made the statement that he will take the stand, and it would be very interesting to I don't know if he would for the evidentiary hearing, but for all these other things, it would be interesting to hear from Mello, Kate Peter, Tully, call them all to the stand, see what they have to say for themselves. All right, that is it for now. Like I said, there is not a current date or rescheduled date on the docket yet, so we're just kind of waiting to see when the new oral arguments or hearing will take place for this motion to dismiss. I think they have some other things. No, well, there are some other things that they kind of put on the back burner because they're waiting for the motion to dismiss. So they need to get that taken care of. A December 1st date for trial is what the court is pushing. So that's what we're looking at. It is May 26th. So that means trial is coming. It's going to get here sooner than later. It's going to probably come fast. And I hope the Commonwealth is ready for all of the truth bombs that the defense has up their sleeve. All right, so that is it. I will see you guys in the next one. Let me know if you have any questions, comments, what you think will likely be Turtleboy's biggest hurdles with the motion to dismiss, or what you think, might work for him. I think he's got a lot in here that might work for him, at least to get the evidentiary hearing. That's what I'm hoping happens, if not fully outright dismissed. I think he'll get the hearing so that they could put some of these people on the stand. Although you know how that goes. And they tried to put Lolly and was it Buchanan? I can't remember who it was for Michael Proctor's texts. What? Oh, there's been so many cases all intermingled, so I can't remember. But there was some hearing where we were supposed to hear from some people we really wanted to hear from, and then all of a sudden it was just like abruptly cut off. You guys know what I'm talking about? I can't remember. It was just abruptly cut off, and then we never heard from them again. And it was people in the investigation, like maybe we could get some answers now in the Karen Reed case, but I can't remember what it was. Anyways, hopefully it comes to me and I can let you guys know. All right. Thank you again for watching. Take care. I'll see you in the next one. Bye, guys. Welcome to the Corruption Files Update. This is your quick hit on the latest filings, breaking news, or bombshell developments in the cases that we follow. No fluff, just the facts that you need right now. Let's dive in.